Justice of the Appellate Division, 4th Department. Hear ye, hear ye, hear ye. All persons having business to do before this court will draw near, give their attendance, and then they shall be heard.
Thank you. Please be seated. Good morning. Before we begin today's calendar, we have 19 candidates for admission to the bar who will be sworn in this morning as attorneys and counselors at law, together with their family and friends who are here to celebrate this achievement with them. Welcome all. At this time, let me just move quickly here. At this time, I'd like to just take a second and indicate to you that a career in the law is very often driven by a desire to be in a position to help people. People are very often at desperate points and times in their lives. And the lawyers that are here today representing clients on appeals to be argued shortly will tell you sitting in your office or in your client's living room to talk to them about cases is a very serious and often sobering moment in your career. Early in my career, I remember thinking, my gosh, what a responsibility I have representing these people in this very serious matter. These are people who feel like there's nowhere to turn. And you, as attorneys and counselors at law, will be the person they turn to. It's an extraordinary gift to be able to help people in such a way and to play such an important role in their lives, in the lives of all of our clients. Alan Ross, Deputy Clerk of the Court and currently Acting Clerk of the Court, will now administer the oath. Mr. Ross, have these candidates been certified to the court for admission by the appropriate committee on character and fitness as possessing the character and fitness required by an attorney and counselor at law? Please administer the oath of office.
I do solemnly swear. That I will support the Constitution of the United States. And the Constitution of the State of New York. And I will faithfully discharge. The duties of an attorney and counselor at law. According to the best of my ability. Congratulations.
I wish you all great success, and I'm confident that the years ahead will be filled with great accomplishment and satisfaction. Congratulations. And we'll get on to our court's calendar at this time.
Clears them out.
What's that?
Clears them out.
Yes, exactly.
Chris, would I like not ready to leave?
From a profile, if they will be.
Okay, very good. The first case on for argument today is case 760, People versus Anderson. Counsel, can you hear us?
Yeah, good morning, Your Honors. Brad Osler on behalf of the people.
We can hear you. I understand that the appellant has submitted.
Yes, and I would just be happy to answer any questions if there are any.
No questions. Thank you, counsel.
Thank you.
Case 761, People versus Speed. Counsel, proceed.
Good morning, Your Honors. Stephanie Stair for Mr. Speed. I will be concentrating on points 1 and 3 of my brief. Point 1 is a 30-30-245 argument. If I'll just go straight through all the COCs. The initial COC was.
Before you go through, let me just ask a quick preservation question, okay? And
Yep.
yeah, I think you know what's coming.
Too late.
Below, we were, it was addressed the initial COC and the first supplemental COC,
Correct,
nothing beyond that.
correct.
Okay. And with respect to preservation, how does that, the fact that that was the only thing argued below, how does that impact your argument today?
Judge, I have two responses to that. Preservation is outlined in CPL 470-05. The last sentence of that section does say a party who without success has expressly sought a particular ruling is deemed to have thereby protested the court's ultimate disposition, regardless of whether actual protest thereto was registered. So counsel did challenge early and timely the first two. Her further argument was sort of tainted by how the court responded to her. Judge Renzi said it's not even relevant. He said the DA says it's not relevant, so you're denied. He didn't even really go into it. I would assume that she felt it was fruitless to continue to object at that point, given that she had already initially objected to those first two. But you are correct that those were the only ones actually objected to.
Okay, very good. Proceed.
The initial COC was invalid and illusory because 911 calls were disclosed thereafter. The initial COC on January 25th indicates that the 911 calls had been, preservation had been requested. That is not the same as making them available for inspection and absolutely not the same thing as disclosure.
Are you referring to the 911 call of the shots fired in this case, or the 911 call that explained why the two arresting officers were in the vicinity at the time?
So the ones that are turned over on February 7th are ones that are uncontestedly related to this case.
Yeah.
The one that about where the.
That are definitely related to this case, as
Definitely.
opposed to, let's call it the U-Haul 911, okay? That'll help
Right,
me
so
at least
The
understand.
U-Haul 911 was disclosed even later than February 7th.
Right.
So February 7th were the related 911 calls.
Right, and your argument with the U-Haul 911 calls, well, the people say those aren't relevant to the case. The U-Haul, there was a man with a gun, allegedly reported a man with a gun in a U-Haul. It wasn't your client, right?
Correct.
Wasn't anyone involved, and wasn't anyone with your client.
No.
So the people say it's not relevant to the subject matter of the case under CPL 240.20 because had nothing to do with him.
So they say it's irrelevant, but they also immediately request it and provide it. And it was relevant enough to be referenced in the investigating officer's police reports. That's how defense counsel was made aware of it and made the DA aware that it hadn't been turned over. So if it was relevant enough for the officers to refer to it, I think that makes it relevant enough for defense counsel to be given it. And all due respect to all the parties, it's not the judge or the DA's job to decide or position to decide what's relevant. That's to a defense, right? The defense attorney gets to make what's the decision, what's relevant to her defense. It serves as a basis, and beyond that, it serves as a basis for explaining why the responding officers were there, their position relative to the crime, their response time, and things of that nature. That call was just not disclosed until March 16th. So that disclosure, we argue, invalidates the February 7th supplemental COC, which was further invalidated by turning over the cell phone records from the search warrant and the defendant's criminal history. The reasoning for not turning it over earlier was that they thought they had, which is not due diligence. And again, that that March 16th disclosure of the U-Haul 911, if we're going to call it that. There was no supplemental filed after that. So after that, time is still running. And by my calculations, and it's well covered in the brief, time doesn't really ever stop until April 15th on filing of motions, and that's 214 days. It's math. I'm not going to belabor the point here. I'll move on to point 3.
Nothing worse than math in public. so.
Right?
Before you get to point 3, which I know you want to get to now, on point 2, just so I can understand, was there any evidence, incriminating evidence obtained by the police as a result of either search warrant?
Not really.
So so that issue, it would be, let's say that one of the warrants was overbroad. It would be harmless because there was no evidence that the police obtained.
Likely, yes.
Okay. Just want to make sure I understood. Thank you.
In regards to point 3, we're arguing that his sentence was harsh and severe. He is a 45-year-old man. He was 43 when this happened. The background is interesting in this case in that he was originally, they attempted to indict him for murder. He was placed between a rock and a hard place. His friend was shot before his eyes. He picked up a gun and fired back, and perhaps saved many more lives in doing so. There was a mitigation report submitted to the court. He has just a horrific childhood, witnessed his father's death at the age of 14. Sister died, younger brother was murdered, physically, emotionally, and verbally abused his entire childhood, but still worked his way to be a support in the community. He was not a predicate for sentencing. His last felony conviction had been for an AUO first around 2018. His minimum in this matter would be 3.5, and we would be asking the court to modify it to that. And if there are no other questions, I would rely on my brief.
Thank you, counsel.
Thank you.
Good morning. May it please the court. Christina Harper for the people. I would concentrate on point 1. As your honors noted, most of the issues raised in point 1 were unpreserved as it pertains to CPL 245 issue. The only issue that's been preserved is the alleged failure to disclose the U-Haul 911 call. And as to that, I would point the court's attention to CPL 245-20 subsection G that states that all tapes or other electronic recording, including all electronic recordings of 911 telephone calls made or received in connection with the alleged criminal incident, must be disclosed.
And so your emphasis is going to be on the words "in connection with," right?
Correct, yeah.
Yeah. And so the argument that your opponent might want to make is, how is this not in connection when you consider it was the U-Haul 911 call that brought the police to the area where they hear shots fired and they respond immediately? How is there not a connection there?
They're not connected, Your Honor, because they're completely 2 separate incidents. The U-Haul incident pertains to completely unrelated shooting. So it just happened that these police officers already were in the area in response to an earlier phone call. Yet these 2 investigations were completely unrelated. None of the individuals involved in the U-Haul incident were related to the incident here, and therefore they're completely unrelated. It just happens to be so that there were 2 shootings that were in close proximity and in close geographical area.
So if the proof at trial was by the people in examining the 911 or the officer relative to the U-Haul 911 call was the argument was made, we just want to complete the narrative so the jury understands why these police officers were so prompt on their response to the shooting, because they heard it, because they were nearby, and we want to explain why they were nearby. That's before the jury. How is that not discoverable?
This case certainly was, there was a plea, so it's really hard to determine what, if any, proof would have been presented at trial. It is entirely possible that this information would not be in front of the jury. It is entirely possible it could be objected to. Also, 911 tape in and of itself is not related to the subject matter of the case that is at bar here. It is an unrelated matter.
Is one of the remedies for a trial court to say, I'm not going to allow that 9/11 tape and information in and not allow the people to connect it up?
Yes, Your Honor, and quite frankly, here Judge Renzi did preclude the 911 tape. That as the U-Haul 911 tape.
Would you agree if we disagreed with you on that? We thought that the U-Haul 911 tape was relevant to this prosecution. Do you disagree with counsel's math that this tape was eventually turned over upon request on March 16th? But there was no supplemental COC for that. If we disagree with you, as to relevancy, do you lose math-wise?
Your Honor, I still, so the 911 tape, it was turned over upon request in a timely fashion, even though it was unrelated. It was turned over, so the request was made around March 5th, and it was turned over around March 16th, shortly after it was received from the Emergency Department Communications.
Does that stop the clock, or does there need to be another COC to stop it with a statement of readiness?
So, Your Honor, that still does not invalidate. I would argue that this does not invalidate the original statement of readiness and certificate of compliance. Taking Bay factors into account, here, the record reflects that the people exercised due diligence and made reasonable efforts in ascertaining all discoverable material. And that is evidenced throughout the record by how diligent the trial DA was in reviewing discovery time and time again, and how promptly he responded to defendant's request, and therefore that does not invalidate the original
We have to
certificate.
go through all the Bay factors.
Yes,
And if we were to conclude that's relevant. But if we agree with you on that, we don't even need to get to those factors.
correct, yeah. And as to, in response to defendant's point 3, Your Honor, this was a negotiated guilty plea. The defendant agreed to 8 years in prison. I would point the court's attention that the maximum allowed would have been 15 years. He received way less than what was allowed, and I would argue respectfully that the sentence he received was not harsh nor severe. Thank you.
Thank you, counsel. Case 863, People versus Collins.
Good morning.
Oh, I said 866, yeah, I'm 100 cases ahead. 763, my apologies. Thanks. Counsel, can you hear us?
I can. Can you hear me?
We can, very well. Thank you very much. Please proceed.
Good morning. May it please the court. Brad Keem. I represent Robert Collins. I'd like to get right into the sufficiency arguments and start with attempted kidnapping in the first degree. We assert that Robert never got dangerously close to abducting Jay, I'll call her. The altercation took place away from Robert's vehicle. He never really had control of Jay, never got her close to his car. The car door was never open. So we would argue that part of attempted kidnapping, but even more apparent was the failure to prove Robert intended to restrain Jay for 12 hours. The residence contained no furniture, no food other than scotch. Robert had prepared his finances, his will, his belongings were in storage. His stated goal was to hold her until she came into reason, came to reason, but based on that evidence, there was no way that this altercation was lasting 12 hours.
Would you agree, Mr. Keem, that the people don't have to prove intent to restrain for 12 hours? That the 12 hours, strict liability, whether you intend to hold somebody that long or not after you abduct them?
I argued in the brief that the 12-hour period was necessary for the people to prove.
Yeah, I agree with it. It's just a question of, does the defendant have to intend to abduct somebody for that period of time? Do the people have to prove intent on that? We know they have to prove intent to abduct. We know they have to prove intent to cause physical injury or one of the other aggravating factors, but does there have to be an intent for kidnapping one to hold somebody for 12 hours or more?
I would assert that there is.
Yeah.
If I could move on to the serious physical injury, Jay never lost consciousness, which would be for the assault in the first degree. She never lost.
Is the argument with the assault, I believe your argument is the assault first can't stand because I thought that there was what is the phrase, serious disfigurement?
Correct.
We're talking about a half an inch to an inch scar on the top of the forehead near the hairline, correct?
Correct.
What did the jury had an opportunity to see this, right?
Yes, they did.
Right. And part of this is what's the public reaction to this, right? So there's some value in the jury seeing this and making the conclusion or being asked to draw the conclusion, does this rise to the level of serious disfigurement? How do you address that?
So, Your Honor, this case is obviously terrifying. And I think that the other parts of this case had a very strong possibility of moving the jury to convict on really anything that was put before them. And I think it's this court's role, as it did in Armstrong, to make sure that scars like this, they only constitute serious physical injury when there's an altered appearance that makes someone distressing or objectionable. That language in Armstrong is important, and I just don't see that was demonstrated in this case.
When you say scars like this, it almost implies like we have a sense of what the jury was looking at on the day of trial when she was asked to step forward, stand up before them. The transcript speaks for itself that can you please pull your hair back to show where the scar is, please, to the jury. I'm referring to page 297 of the transcript. The photos that we've got a series of photos from the day of the incident where arguably very distressing photos, but day of the accident, a lot of blood, et cetera. A couple days later, with the stitches and everything else, also, I would argue, distressing. And then we have only one photo, it looks like, after the stitches were removed, maybe a couple of weeks later. And then we have 5 months go by. And whatever happens to the scar happens to the scar. We would like to assume that it got better. The jury saw her. We have no other photos. What are we to do with that?
Yeah, I agree. I would have loved to see more photos from the trial to understand what the jury saw and why they found this to be serious physical injury based on those scars. But again, I think that it's this court's role, it's the people's burden then to demonstrate that there was an altered appearance that's distressing or objectionable, that scar. And I don't think that they met that burden based on what was before the jury.
Well, they may have, depending, we don't know what the scar looked like, as Justice Noack said, but would your argument be the most recent photograph was taken how soon before trial? The one that's in the record? Number of months before trial?
Yeah, yes.
Right. I don't have it in front of me, but I have looked at it, as have all of us, and I'm not sure that rises to the level of a serious physical injury, given its location.
Right. And
we know that location matters. If it were on the cheek or in someplace like that, totally different ballgame. But my recollection was that it was a scar and then it came down a little bit under her hairline, just a fraction. Are we, if you're right on the photograph, it certainly probably didn't get worse between the photograph and trial. So if we agree with you that photograph doesn't establish disfigurement, then stands to reason the people didn't meet their burden at trial.
Correct, Your Honor. And I would also point that those photographs, there's so much blood in the hair, it's almost distracting from what the question is, which is the scar itself. And I think that that very probably moved the jury. And again, this is a terrifying case, but it's this court's function to ensure that the people are held to the standard and that the elements are actually proven.
So counsel, let me ask a question though, with respect to where the burden lies here, right? So the people put their case on with respect to to meeting their burden, and they believe they carried the burden. If in fact, part of the defense is to demonstrate what the scar looked like at the time of trial, right? And they wanted to put a photo in of what the injury looked like at the time of trial. Doesn't the defense, if they're trying to put that proof on, don't they have an obligation to make the record here?
Well, certainly, Your Honor. I would, as I indicated to Justice Lindley, I would have loved to have a photograph of Jay from the time that she testified, but we don't have that. And I don't think that based on the evidence that is on this record, that we can say that the scar at any time met the standard for a serious physical injury.
And that's really a question. Does the evidence that was put before the jury, does that rise to the level? But certainly at the time of trial, defense counsel could have, if they felt that the view at the time of trial was so, say it over time, over those 4 or 5 months, it healed much better and the appearance looked better. Certainly defense counsel could have put that proof in as part of the case to make the record.
Yeah, and I mean, at trial, she had changed the way that she parted her hair. So I don't even think that the scar was actually visible in the way that she modified her hairstyle. And perhaps defense counsel found that to be sufficient to demonstrate the lack of serious physical injury. I didn't think that reached the level of ineffective or anything, simply because I just, based on this record, didn't think that the people demonstrated serious physical injury.
Well, how could a defense lawyer create a record of what a scar looks like at the time of trial? Could a defense lawyer at trial say, Judge, I want to take a photograph right here in the courtroom of the victim? Is that even permissible? I've never seen that. Or would it have been up to the defense lawyer in cross-examination of the victim to inquire, ask questions about the healing nature of the scar and how things, whether it looks the same now as it did with the last photograph? Is that the only way defense counsel could have gotten what you wanted? You say you would love to have a photograph. Is that the only way to do it on cross-examination?
Your Honor, I think it may be. It's an interesting question. I think the photograph, why I would like it is because I think it would only help my argument. I certainly think that the transcript, though, it speaks for itself in terms of, her having to flip her hair, the part of it, I don't think necessarily leads to serious physical injury.
Counsel, there would be nothing stopping defense counsel at the time of trial when the prosecutor asked for the opportunity to allow the victim to display to the jury the condition of the scar. There'd be nothing stopping defense counsel to ask the court for, even off the record outside the jury, for a photo to be made as part of an offer of proof for appellate purposes. There's no reason why that couldn't have happened here, right?
It's certainly possible, Your Honor, but again, I think the inquiry that you're kind of going back and forth with right now isn't I don't want to get lost here. What is on the record is on the record. And what we have is...
You say even the scar as we see it in the earlier photo is not enough to get us there.
Exactly, because it's blood in her hair that is not related to the scar at all. It looks grisly, it's horrible, but it's not serious physical injury just because it's, because of the blood.
You'd rather not have us get lost in the other argument. Very good. Anything further, counsel?
Your Honors, unless there are questions about the photos or the nature of the sentence, especially considering some of the comments of the trial court, I will rely on the brief.
Very good. Thank you, counsel.
Good morning, Your Honors. May it please the court. Kelly Wolford on behalf of the people. I'll address the scar first, since that is where we were left off. First, I do think that counsel for the defendant could have made a record of a lack of significant scar by asking the same questions that a prosecutor would to establish a record for a positive scar. So say, for instance, the defense attorney believed that the scar was not significant or disfiguring. The attorney could have made a record that said, I'm pointing to the upper part of my scalp and my hairline, and would you agree with me that that scar only comes down however long it was showing on that date? So, oftentimes we're in a situation where things are occurring on the stand during a trial that we're not going to get a picture, we're not going to get a video of what is happening, but it's on counsel to make sure that that record is clear, and that sometimes we can use our words. It's not as great as a picture might be, but sometimes you can use your words to make sure that we have that record.
So in this case, the people have documented, of course, that the injury occurred.
Yes.
Early photographs of the injury, early photographs of the scar, the victim standing up before the jury, come here, if you will, please move slowly down here so all the jurors have an opportunity to see. All of that's in the record.
Right.
It would seem to me that what defense counsel is asking is that we create an additional burden, that now the people need to take a photo the day of trial and have that put in the record as well for the people to meet their burden. Otherwise, the people can't meet their burden, even though they've done everything that they've done here.
Right.
Do you agree with that?
Absolutely not. I think given the circumstances and the need for serious physical injury to establish permanent disfigurement, the original pictures are important, but they're not the end all be all. What that person looked like, what Jackie looked like in front of the jury is the most important thing. And that's why we have juries, right? So that they can take a look at the person standing in front of them and make a determination. And she is a woman who has a scar on her face, and so she can change her part and cover it. It doesn't mean it's any less of a disfigurement to her. She shouldn't have to change her hairstyle in order to cover a scar that was left by this individual. The fact that she did have to do that does show us that she's disfigured.
Right. Well, that's a point I think I was going to make as well. I mean, you're dealing with a situation where, okay, you've had this, and would normally, if she didn't part her hair, would the public think that's a serious disfigurement, based upon that? Now,
Right.
Now I'm compelled or forced to do this, because of this fact that I have this scar that, on my forehead.
And that would be my argument, that she shouldn't have to take different steps to make sure that people can't see something that is disfiguring on her face that was caused by this defendant.
Well, two things I would say. One, first of all, just for purposes of the record, I don't know that it was defense counsel that was asking us to make a new standard. The defense counsel's argument was, look, there's enough there in the record as it is. It was me that went down the rabbit hole there as far as making a new rule. So I wanted to clear that up. But with respect to the hair movement, changing your hairstyle, certainly you're not proposing to us that if a victim who can cover a scar by changing their hair style, that is evidence that this is a significantly disfiguring injury.
No,
You're not saying that, because
I think as with every serious physical injury, it's a matter of it's factual.
Is it the victim's view of how this looks that's important, or is it an objective view of how the public reacts to it?
I think it's an objective view. And I think we had 12 objective people who took a look at this woman, and they were shown her scar, and 12 people agreed that it was disfiguring. And that's what's important.
Right, and I get that, but on the other hand, if that can't be the only criterion, in that the jury saw it and they found the scar on scar cases, they found it to be significant disfigurement, we would just affirm those. We would never modify or reduce them. And we know that a scar isn't enough for serious disfigurement. And here it does, I think it's undisputed, most of the scar, talking about the scar.
The scar on the front.
There was something on the ears where, well, not.
In the back of her head.
Yeah, the scar at the forehead, I think it was undisputed that the large portion of that was covered by her hairline, even if she doesn't change her hairstyle. There was a portion of it that would creep down a little bit.
Right. It was undisputed that part of the scar went into her hair and then part of the scar came down into her forehead.
Right. But we'd be assuming if it was all covered by the hair, are we to assume that she's never gonna lose her hair?
Well,
How does the hair?
I don't think
Okay.
that we can assume anything, Judge. I think what we have to do is look at placement on the body as a part of what is considered by the courts in determining whether or not something is disfiguring, right? So this court, as well as all the other courts of the state, look to, what may be a scar on your forearm may be very different than a scar that's on your face. And
Does it matter that it's a female as opposed to a male? Does it matter the age?
that is a trick question, Judge.
No. Or does it matter the age of the victim?
I do think it matters the age. I do think it matters to a certain extent that it's a female.
All of those things.
All of those things come
we
into
have to
play.
consider.
Absolutely.
Yeah.
I mean, no, nothing really turns on this significant because you got concurrent time. This would be an
Right.
attempted assault
Right.
at the least. On the issue that matters for him, as far as a more reduction of the time on
On
the
the
kidnapping
kidnapping.
first. He was convicted of attempted kidnapping first,
Right.
under the provision that said you commit that crime by abducting somebody and restraining for more than 12 hours with intent to either cause physical injury or do something else.
Right.
Is that even a cognizable crime if you're not successful with the abduction?
I do believe it is, Judge. I think that the way the statute reads is it must be with the intent to abduct for longer than 12 hours. I think it is the reason that 12 hours is there is because abduction can happen in an instant, right? Where you take somebody and you take them to a different location and maybe it's over in 10 minutes. But when you intend to abduct somebody for an extended period of time, we're going to go to a higher level of kidnapping. And that's where the 12 hours comes in. Does it have to be, I specifically want to take this person for longer than half a day? I think ultimately what the burden is to show that the abduction was to be for a substantial period of
That was
time.
the intent at the outset. So you and Mr. Keem agree on that there's an intent element to the 12 hours.
Yes,
So if a defendant were to abduct somebody and at the time of abduction, I'm going to kill this person. And then something happens and that the victim is held for more than 12 hours. It's not a defense for the defendant to say, well, I never intended to hold this person for more than 12 hours. That's not, that would be a defense in your view though, right? Because there's no intent to hold for more than 12 hours.
that's a defense.
That's a defense, okay. And if
Yes,
you're right,
and-
then you can be convicted of attempt here.
Correct. I don't think you can otherwise get to an attempt here. It would be an attempted kidnapping second. I agree with you.
So then what evidence do we have of an intent for him to hold her for more than 12 hours?
So he goes, first of all, his statements are the best evidence of his intent, right? His statements are that he was going to hold her until she came to reason, which clearly we know from the facts that she was not going willingly. And she was not going to suddenly fall in love with him like he had hoped. He also had duct tape, he had twine, he had a hand or a firearm. His preparation was clearly to hold her for a significant period of time. And ultimately his goal was to hold her for as long as it took to have her come to reason. And if that didn't happen, he was going to kill her. So in this particular case, the jury was entitled to find that it was his intent to hold her for as long as that took, which given the facts and circumstances of the case would have been more than 12 hours.
Any further?
No, thank you.
Thank you, Councilman. 7-6-4 People versus Lloyd. Proceed, Council.
May it please the court, I'm Tanya Plank for David Lloyd. I want to focus on the ineffective assistance of counsel point, which involves the suppression issue as well. My argument is because of defense counsel's numerous errors, he failed to provide meaningful representation to Mr. Lloyd. Most importantly, he failed to argue after the hearing that the people failed to go forward in the first instance with evidence that the police conduct in recovering the gun was legal, since the people provided no evidence whatsoever of the gun's recovery. Instead, he made several arguments without any evidentiary support, that the troopers were racist, that this GIV unit was racist, no evidentiary support for that at all, and that
The
Trooper
argument was, though, he threw the gun out the window, right? They had to go back and recover it.
well,
Correct.
that wasn't, I mean, that wasn't elicited at the hearing, but
Right,
that was in the
because-
police report. It was in
Yep.
the police report, yes. So, I mean, there was no evidence at the hearing that was elicited about this gun's recovery,
The
so I
gun
don't know anything
recovery.
about it.
But below, I'm sorry, go ahead.
Go ahead.
Sorry.
But below, the argument was that there was no probable cause for the stop. That was
Well-
when it's a suppression hearing.
I would argue that I mean, that's one of the problems, I think, with his representation. He made different arguments and they're confusing. In his omnibus motion, he did say that there was no probable cause for the arrest. That was the omnibus motion. And then after the hearing,
He argued that he was wearing a seatbelt.
right, there was the argument, right. He argued that the officers were lying about seeing the seatbelt. about-
David, but that's, go ahead, yeah.
Right. I mean, that was the argument below. And then, but also he focused on, I think it's interesting, he focused on Trooper Ferguson and said that Trooper Ferguson had all these credibility issues, and it wasn't Trooper Ferguson who testified, it was
It
Trooper
was Manley,
Manley.
right? It was
Right.
Manley.
So it was the wrong officer. He had the wrong officer. And then he also never he never gave any support for Trooper Ferguson's apparent alleged inaccuracies and lack of credibility. So, and then, I mean, he attached this big long crime report.
What about the fact that this is GIB,
Right,
you know, is the purpose is to make traffic stops?
right.
Right, I mean, what about that? You
I
know,
mean, well, he argued that it's a pretext. It's a unit that is supposed to be, that is racist, and they do racist pretext stops. But he didn't give any evidence of that. So, I mean,
That's
there
not
could be
a-
evidence, but,
Not a valid legal theory anyways, right? The police
right,
can
right.
Pretextually stop.
Right, and it's not,
That's not-
right, that's been held not to be correct.
Can I just get clarification? Because I'm a little
Sure.
confused and it's my fault, but what are you saying that the police did wrong here? Was it the initial pursuit on the seatbelt? Was it the arrest? Was it the search of the car? What do
Well,
you think they went wrong?
I mean, my argument is basically that we don't know because we don't know anything about this recovery of the gun, and there really should have been evidence about the recovery of the gun.
Right.
So we don't know where exactly it was recovered from. I mean, I know what the
The
police
only way
report
the gun
said.
could be suppressed, correct me if I'm wrong, the
Mhm.
only way the gun would be suppressed is if the police unlawfully pursued him on a seatbelt violation that didn't exist, if the police were lying about that, right? Because if you toss a gun
Right. it
while the
would be
police are
bad.
following you, if they're not supposed to be following you, then
Be
the gun would
bad.
get suppressed.
Right,
That's the only way, right? So the defendant would have to prove that the police were lying about, the officer was the trooper, I think it was, lying about not seeing him wear a seatbelt. Or seeing him not wear a seatbelt. That's the only way he could get this gun suppressed because it was abandoned. What happens after the car stopped and the
So-
search and all that, the gun's already discarded. Am I right here?
we don't, I mean, again, I would argue that we don't know anything about the gun because because there was no testimony elicited at the hearing about the gun. So we really don't know anything about when the gun was discarded, where exactly it was discarded, how it was discarded, who found it, and
So
how.
following that theory from Justice Lindley, was it error then for the defense counsel merely to attack the lack of probable cause to make the stop initially in the first place?
Well, I think, I mean, he could have done other things too as well. Like he could have argued that the search of the car was not a valid inventory search since that was what was testified to at the hearing.
What did they get from that search?
Well, the marijuana was in open view, but they found the bullets, and the bullets could have been tied to the gun
That's fair.
if the people, I mean, it wasn't proven at the hearing, but
Sure.
presumably that would have been proof at the trial that the bullets were tied to the gun, presumably. So
Right. You
if
wouldn't-
that was suppressed,
Okay, there's something to suppress there.
right. So that could have been suppressed, and he did not make the valid argument. He didn't make any argument. He made an argument about it went beyond the probable cause search, but The testimony was
That
that-
was an improper inventory search then, because the fact that the marijuana was in plain view, correct?
Right, that was in plain
At that point in
view.
time, and up till 12 days later is when it became legal.
Right,
So at the point in time, it was illegal. They make an arrest, do an inventory search, find the bullets and find the magazine and.
well, I argued, I cited the case, People v. Martin, I think it's called, in my reply brief about that held that if the hearing is held after the MRTA was passed, then that would be, and that's not a valid reason for not suppressing the marijuana. As far as the bullets go, the inventory search, there was no testimony about the police procedure, the exact police procedure that needs to be, that goes into the inventory search, and that it was.
Then they claimed that it had to be towed, so that's
Right.
the inventory.
Right. But there wasn't any testimony about like exactly what exactly the police procedure was and all that. I think I cited that case in my reply brief.
Counsel, I'm gonna go back to a
Mhm.
question that I'm not sure that we got an answer for. The police below
Mhm.
in the hearing, the argument was that the police saw that there was no seatbelt being used. They turned and began following the car. That's when the chase began, correct?
Correct. Right.
So the whole premise upon which the follow and then the attempt to pull over was no seatbelt.
Right.
Are you arguing that was not sufficient to pursue and to attempt to pull over the vehicle? The fact that the officers saw that there was no seatbelt. I'd like an answer to that question.
Yes, that was sufficient. But I don't think they would have arrested him for that alone.
But that's sufficient. In other
Right.
words, it's sufficient for them to pursue the vehicle and attempt to pull the vehicle over for purposes of no seatbelt.
Right.
Okay. In order for us to find that the argument below that that he was wearing a seatbelt and it was pretextual, we'd have to find that the officers were not telling the truth. The court didn't
Right.
find that, right? Court below didn't find.
No, the
make a
court didn't.
finding of no credibility on behalf of the officers.
Right. No, the court didn't find that.
So we'd have to do that independently, based on the record before us.
Right.
You're not asking us to do that.
No.
Okay.
Right.
Very good. Thank you.
And
With respect to the testimony that was at the hearing about the a recovery of the gun, I agree
Right.
with you that there was just the one question that in
Right.
fact, a gun was recovered and that was it.
Right.
Pretty much it. I went back and I took a look at the motion to suppress that was made
Right.
back in the record. And the motion to suppress is really only about the seatbelt. It's really about a failure to chase and seatbelt. And this is, pages 2021 of the record or of the appendix. Are you claiming as part of the ineffective assistance of counsel that the motion was too limited? Because it seems to me that if you read what the motion was, and really what they were seeking was a probable cause hearing than a suppression hearing. It was called a probable cause hearing. I guess it could be both, but
Right.
it seemed to me that really what they did was focused on what was claimed in the motion
right.
at the hearing. If the motion for suppression had been made differently, where there was a motion saying, oh, and by the way, we think that the effort to recover the gun was improper. Well, then perhaps you have more testimony, but we didn't have the testimony because it wasn't requested in the motion. Would you disagree with me there?
Right. I just think I think that the motion was limited, especially given his post-hearing arguments, where he makes this big showing that about the recovery of the gun and that the gun wasn't recovered until after the arrest and the towing. And he provided this long crime report. I mean, it doesn't make sense why he did that and why he made that argument when he didn't make that argument in his original suppression motion. So I think it's just confusing. And then I think it confused the judge too. And I think the big problem here is that the judge's decision is clearly wrong because the gun was not recovered pursuant to the inventory search.
That was a factual mistake.
Right. It was a factual mistake. And
which hurts the defendant because it's hard to suppress a gun that's on the lawn somewhere on the side of the road. Hard to suppress that based on what happens after the defendant comes to a stop.
right. But I would still argue that at a minimum, this court should remit to the trial court for an analysis based on the correct facts.
We'll take a look at that argument, Counsel. Thank you.
Thanks.
Good morning, Your Honors. May it please the court, Lisa Gray on behalf of the people. With respect to the effective assistance of counsel claim, it was clear from the way the motion was pleaded below that counsel certainly pinpointed what the material fact at issue was at the hearing, and that was whether or not there was a valid vehicle and traffic stop. And with respect to that, the recovery of the firearm in and of itself wasn't the material fact at the hearing. It was whether or not the police officers or the troopers in this case made those observations that they alleged to have made. And it wasn't counsel's purpose in just attacking the GIVE program in and of itself as being racially motivated. The trooper also cross-examined the trooper. The defense counsel also cross-examined the trooper on things like how quickly the events were occurring, how quickly Mr. Lloyd passed him in his vehicle, the difference in the height of the trooper vehicle versus the Porsche that Mr. Lloyd was driving. So it wasn't in and of itself a race-based argument.
It happened in daylight too.
And it happened in daylight, 1:30 in the afternoon. It was
Nobody
bright
else was in
outside.
the car.
Correct. All of those factors, Your Honor. So points 1 and 2 sort of are inextricably linked to a certain extent. But certainly looking at this case as a whole, counsel was certainly effective in attacking the credibility of the police officers. He wasn't ultimately successful, but clearly there was strategy to that. And indeed, again, kind of going back to the fact that the material fact that was pleaded below was whether or not that traffic stop was lawful from its inception. And as you follow the sequence of events during the hearing, every step the police officers took was lawful. There was no seatbelts. It was a high rate of speed. They blew through a stop sign. They went the wrong way on a one-way street. They ultimately crashed. He ultimately crashed his vehicle. And at that point, the troopers were in a lawful position then to see the marijuana. So really, the recovery of the firearm was of no moment, really, because it was the burden of production at the hearing, which the people met, and that was the police interaction with Mr. Lloyd was lawful at its inception all the way through. And again, with respect to effective assistance of counsel, again, you have to look at whether or not this is an advantageous plea. Mr. Lloyd is a second violent felony offender. He received just 1 year above the maximum term of incarceration as a second violent felony offender. So all things considered, with respect to misnaming the trooper in the closing memo that was supplied to the hearing court, I attribute that to just a mistake on the part of counsel. Clearly, it was Trooper Manley who was testifying. I think there was a little bit of confusion on Manley's part in terms of who was driving or who was passenger, and he cleared that up quickly. So I attribute to the mistake in the closing memo to maybe just a mismemory on the part of counsel, but that in and of itself.
And had counsel raised the issue of the gun that was found on the lawn, that actually wasn't thrown out of the window of the vehicle. Let's take a look at it. There's no evidence that argument would have had any merit.
Correct. Unless there are any other questions, I would rely on my brief.
No other questions, counsel. Thank you. Case 768, Atatsi versus State of New York.
Good morning. May it please the court?
Good morning. Let's make sure everybody can hear us. Counsel Kitten, can you hear us?
Yes, Your Honor.
And we can hear you. And counsel, we heard you clearly. Very good. Proceed.
Good morning, Your Honor. May it please the court. Amy Bedell for the state. I'd like to focus first on our main argument, which is that the claimant, just as a threshold matter, is unable to identify the cause for fall without resorting to speculation, which is insufficient to raise a trialable fact in opposition to the state's motion for summary judgment. Number one, as the court is aware, in the claim itself, the claimant stated that she was almost at her floor in the dormitory when my left foot went out because of water on the stairs. Now, in her deposition testimony, she very clearly admits that that was only an assumption. In fact, when she's asked the source of that, of her claim, she says, quote, "I was assuming it was water." Further.
Counsel, in your brief, you'd indicated that the court committed reversible error. I'm referring to page 26. When the court failed to consider the claimant's statements, these contradictory statements, it looks to me when I read the court's decision that the court actually did consider the statements. And in fact, the court found that the state met its burden that the cause of the fall was speculative in part because of those contradictory statements. Do you agree, or do you think the court didn't consider them at all?
I think the court didn't. Well, the court agreed that she assumed that she slipped on water, number one. And I think the court didn't consider the totality of her statements as we presented them, including to police officer McDonald, where she stated consistently to Officer McDonald, to the assistant hall director, to the EMT personnel, to the hospital, all of which in each of them stating consistently the same thing, that she stumbled on the last step and fell. At no time in any of those statements did she state that she slipped on water.
But it sounds to me like you're suggesting that if we have a plaintiff that gives contradictory statements, the court is bound to accept the statements that benefit the state.
Well, no,
it seems to me that this is summary judgment. The state has the burden.
Right, I understand that, but it wasn't contradictory. It's that she cannot identify the cause of her fall because she stated that she completely assumed that it was water.
Right, but let me just.
Which means that it was not.
Could we examine that claim for a second?
Sure.
During her deposition, she was asked, how do you know it was water as opposed to some other slippery substance? It was on page 100 of her deposition. As opposed to some other liquid substance. And she said, I assumed it was water because there was snow. Okay, maybe it's not water, but there was some slippery substance there, just as bad. I think that's how I read it. It wasn't that she was unsure if she slipped on a slippery substance. She was unsure if that slippery substance was water. And it's immaterial whether it was water or it was Diet Coke or it was coffee or what have you.
Well, Your Honor, it's our position that it's throughout her testimony, she assumed what it was, and she stated that she did not remember. She stated that she did not remember, that she stated that she stumbled and fell. She did not, to each and every contemporaneous conversation that she had the morning of the accident.
I know that you've compared this case to Waddell, our case from 2023. And I went back, took a look at that decision. The decision doesn't go through a lot of the facts. Did you have an opportunity to look at either the briefs or the record on appeal in Waddell to see if it really is similar to this case?
I apologize. No, Your Honor, I did not. But
okay. You don't know whether Waddell involved a non-party witness like Ms. Davis, who showed up moments after and said, oh no, it was water from the snow. I could see the salt. I could tell that it was, what we typically have when you get a big snowfall here.
Well, I would like to address Ms. Davis's testimony, if I may.
Sure.
One, in addition to the fact, well, first, her testimony, we say, is speculative. She does not identify anywhere near where the plaintiff actually fell, if the plaintiff can even pinpoint that location. We say that testimony is also speculative. It was unwitnessed. And if she did see water, it was 15 minutes after the fall, which we know that in order to establish constructive notice, the condition needs to be there for a sufficient length of time for the defendant to have remedied it.
That's a different issue. The first issue you're talking about is, it sounds like she's making up the fact that she slipped on water, as opposed to what she apparently told medical personnel and others that she skipped a step or she misstepped with her slippers and so forth. But whether the water was there for a constructive notice period of time is a whole nother matter. It assumes that the water was actually there. The problem, and I think Judge Nowak mentioned this earlier, is that I get why you're skeptical, and I get why that you don't think this is a strong case, but you have the burden on summary judgment. And proving for a defendant on a slip and fall to prove lack of constructive notice, you don't know how long the water was there either. You have that burden on the motion for summary judgment. They'll have it at trial. It's a tough burden for you to to overcome here with constructive notice if you don't have inspections.
Right. Well, I think our initial argument, our strongest argument, is that it was assumed that she fell on water, that we have all of this admissible evidence that she stumbled and fell, that had nothing to do with water.
Right.
And that testimony from Ms. Davis is also speculative, and there's no connection between that and the plaintiff's testimony, because it's actually, plaintiff cannot identify her fall.
Well, we'll take a look at that argument, counsel. Anything further?
Just too quickly back to the constructive notice issue. In addition to the Miss Davis having come down after the accident and having claimed to have seen water somewhere on the stair, it is well known that a general awareness of water somewhere in the general vicinity is insufficient, as well as the fact that there was traffic in between when Miss Davis came and when the fall occurred. There was a male student that had appeared who had called 911. Just the crux of our argument in that respect is that in addition to the cleaning schedule, that was they checked the stairs from 8 o'clock in the morning the day before until 10:30 at night. They come back at 8 o'clock in the morning on Saturdays. The students left. The claimant and her friends left the night before at 10 to 11 p.m., went across down the same stairs, back up the same stairs without any issue. And that just generally the plaintiff is unable to establish those as well.
Just if I could come back to Ms. Davis real quickly, you
Sure.
mentioned that she got there 15 minutes. Where did you, for me, it seemed like it was less. It seemed that she falls, her ankles dislocated, bones sticking through her skin, calls her roommate. She comes immediately saying, she thought she broke her ankle, but she said, it felt to me reading the transcripts that it was about a minute. So I don't know where the 15 comes, the extra 14 minutes come from. Where do you get that?
I can forward those citations to the court, but I believe the testimony is that she first called her father and then she spoke to her mother, and that those phone calls lasted about 15 minutes total, and then that she called Gabby.
Fair enough. Okay. The Ms. Davis's testimony is that she saw the water on the first and the fifth steps, and then the last two steps from the second floor landing. There's only 8 steps. You've got a photograph of all the steps that we're talking about from the prior landing to this landing. So it looks like Ms. Davis is claiming there was water on half the steps.
Right. Well, again,
including those closer to the landing where she ended up.
Right. Well, again, our argument is also that it's speculative that she fell on that, speculative that it was there 15 minutes even before without any connection to the plaintiff's testimony and her contemporaneous admissions and, to all of these other third parties that responded to the scene.
Very good. Thank you, counsel.
Thank you.
Counsel, proceed.
Good morning, Your Honors. May it please the court. My name is Cheryl Caton and I represent the plaintiff respondent. We respectfully ask this court to affirm the lower court's judgment rendered on July 26, 2024, which applied the correct law to the facts in the plaintiff's case. I will address the reasons why the lower court's decision and order should be upheld. The claimant's assertions are not speculative, as the defendant argues. Defendant states that the State University of Buffalo did not have actual and/or constructive notice of the slippery, dangerous condition. Additionally, the defendant next argued that their witnesses and their third-party witnesses and the claimant herself at different versions of how this plaintiff came to slip and fall on the steps. The plaintiff stated in her deposition testimony that she did not see the water on the steps, but assumed it was water because it had snowed overnight. She further stated that her Crocs felt slippery. The plaintiff did call her friend Gabriella Davis to the accident site within a very short time period, not 15 minutes, as you just heard. Ms. Davis did.
Well, counsel, what's your, let me follow up on the question that Justice North raised. What's your recollection of the record with respect to the time frame? Is there testimony in the record that would indicate that the plaintiff made a couple of calls and that there was testimony concerning how long those calls lasted that would get us up to a 15-minute gap?
No, Your Honor. I believe that she did testify. She called her dad crying, and I don't know what the conversation was, but it did not last long at all. And she did call.
What in the record tells you that it did not last long at all?
I don't have it in front of me at this moment, Your Honor. I have to go back. I'm sorry.
Then there was another call. Is there any indication in the other call, as far as your recollection of the record, as to how long the second call lasted?
No, Your Honor.
Okay.
I believe she called Miss Davis immediately. That was her roommate, who she was upstairs. She was literally, I think, 30 seconds to a minute.
So do you
away.
I hate to just beat this drum, but do you disagree that with your opposing counsel? I believe opposing counsel is arguing there were two phone calls before she called Davis. You just said she called Davis immediately. What does the record tell us about what was the order of the phone calls?
I believe it was her dad and or mom. I don't think it was two separate phone calls. And then she called Miss Davis.
All right, very good.
Okay. So after she called her friend, Miss Davis, who came to the site immediately, Miss Davis then testified on, I believe it was 12/12 of 23. She came to the area where plaintiff was obviously lying on the floor. She saw that her ankle was dislocated, the bone was out. She noticed that there was water all over her pants. She also testified that she had used those steps the day before and they were wet then. So she was aware of the condition. She stated that these stairs are not regularly cleaned and are often messy. She then accompanied Miss Atassi to the
Counsel, counsel, let me interrupt you. These stairs, the door that enters from the outside to these stairs, that's not a swipe door, correct?
I believe you're correct, Your Honor.
Right. It's not. Let me finish it.
Sorry.
So it's not a swipe door. There's swipe entrances to the building, correct? Those are the doors that students are expected to use their swipe cards to gain entry to, correct?
Correct. However,
doesn't the record tell us in this case that the only way, and I'm referring now to the testimony of Mr. Oliver, who works for the defendant, the only way to get in to through that door to access those stairs from the outside would be to have somebody hold the door open for you from the inside. In other words, there's no ability to get through that door unless somebody from the inside pops the door for you, correct?
That is correct, Your Honor. However, students are always opening those doors for other students and or teachers to come in.
Well, I don't know about always, but Mr. Oliver said
not always. Not always.
Counsel,
Okay.
yeah. Counsel, Mr. Oliver does say that he's seen that happen on many occasions.
Yes.
Right. All right. And so it's not an infrequent thing to have happen there, which would, it seems to me, put the defendant on notice that students are coming from the outside into that stairwell and no doubt dragging, when it's snowing, dragging the snow in with them.
That is correct, Your Honor.
Okay.
Okay, so Mr. Oliver then testified on 11/2 of 23, and he had stated that there were no calls made for the week of plaintiff's fall, and that at least once a day those stairwells are checked. The lower court did agree that although plaintiff's testimony, she could not identify the cause of her fall, Ms. Davis's testimony that she saw the water on the stairs and on her clothes were in fact in dispute. All of the defendant's non-party witnesses could not state whether there was any water on the steps. This certainly points to a question of fact as to the cause of what caused plaintiff to fall and the credibility of all the witnesses. Credibility, as this court knows, is a jury determination at the summary judgment level. A judge only can grant summary judgment when there are no facts in evidence.
Counsel, your argument essentially is that your opponent says that it was speculation and there's only speculation. You say that it's not speculation, that there are facts. We have witnesses that can testify concerning the condition of the stairs, that there was water on there, and that we should leave this to the jury to decide. Isn't that correct?
That is correct, Your Honor.
Anything further, counsel?
General testimony also about cleaning practices. There was no evidence of any specific inspection done by this defendant or when this stairway was last inspected as well. Defendant failed to establish their prima facie entitlement to summary judgment as a matter of law. And accordingly, the court got it right the first time, and this court should affirm.
Thank you, counsel.
Thank you.
Case 769, English versus Brady. You say, counsel.
Good morning, Your Honor. So may it please the court. Carl Dubel from Bond, Shinnick & King on behalf of defendant appellant Brandon Brady. The trial court erred in granting the plaintiff's motion to amend the complaint because the proposed amendment was palpably improper for three principal reasons. First, the proposed amendment was time barred by the statute of limitations. The proposed claim seeks an entirely inappropriate remedy given the
Counsel, let me ask you a question. If we reach the determination that the statute ran before the amendment was the motion for leave to amend was filed, is that game, set, match?
Yes, Your Honor, but I believe the whether you look at it from the time that the motion to amend was filed or whether the time of the original complaint, it's untimely under both of those analyses, and that's the principal reason why the proposed amendment lacks merit in this.
So even if we acknowledge that usually the motion for leave to amend is within the discretion of the trial court to make, that your argument is true, but it's an abuse of that discretion if the statute's wrong.
Correct, Judge. I don't think the trial court has the discretion to allow an untimely claim that's barred by the statute of limitations. I think that's a pretty clear line. And I know in this case, the trial court found that the transaction, the claim arose from the same transactions or occurrence, but that's pretty much irrelevant in this case because that only allows the plaintiff to interpose the claim to the date of the original complaint, which, as we've discussed, even from that point in time, the claim was well time barred because it was the statute of limitations is 6 years and it began to run in 2012, and the plaintiff did not file their original complaint until 2023.
And also the plaintiff was aware, correct? I think even there was a letter that went back and forth from 2019, correct? Actually, 2018 was when plaintiff first wrote a letter to defense counsel, correct?
Yes, Judge, that goes to our waiver argument, which is that the plaintiff had a discussion about his attorney about a dispute that was brewing about this provision in 2018, and letters were exchanged between the attorneys back and forth. And again, the plaintiff did not even bring the original complaint until 2023.
The dispute here, if there's a misunderstanding, was over mineral rights. Did this apply? Did the seller have rights to only things that you dig up out of the ground, or surface rights like solar panels? That there's allegedly no meeting of the minds on that issue. Is that where the confusion was?
Well, I think, Judge, that goes to the merits of their breach of contract claim, which is the original claim that we brought, which for purposes of this amendment is not particularly relevant. But
right, but it's relevant to when the claim could have been brought, could have been filed.
True.
The knowledge of this dispute over mineral rights versus surface rights, that was known to the plaintiff within the statute of limitations.
Your Honor, as far as when the plaintiff learned about this dispute, that's only relevant. It's our position to the issue of waiver. It's not relevant to the issue of statute of limitations because the cases we cite in our brief establish that it's not when the plaintiff learns about their rescission claim. It's the date of the execution of the contract is when the statute of limitation accruals. So even if they learned potentially about this dispute in 2018, The 6-year statute of limitations ran from the date of the execution, which was in 2012. If I could just address the second point in our brief, which is the claim for an equitable remedy. That is entirely improper in this case, based on the facts. Rescission as an equitable remedy is only allowed when the plaintiff does not have an adequate remedy at law, and that's not the case here. If plaintiff's interpretation of the mineral rights provision is correct, that he would be entitled to 50% of the rents generated from the solar lease. That would make him entirely whole, and there's no reason to get to any sort of equitable remedy because he has a perfectly viable remedy at law.
If your client establishes that there was no meeting of the minds, then that claim fails. You can't breach a contract if there's no meeting of the minds to begin with, right?
Well, our position, Judge, is that there was a contract and there was a meeting of the minds, which the contract was in 2012. And then our position.
Sure, I understand that there's going to be an argument. Well, there's an ambiguity in there. Let's look at extrinsic evidence, et cetera. And, which was correct and which was not. I realize that's still a live issue here, but my point is when you say no adequate remedy of law, do you look at a claim that's pending, or do you look at what if that claim fails?
I don't think you get into the analysis of whether they are right or wrong on their legal claim. It's a simple analysis of whether rescission is appropriate at all. And in this case, it's not in relation to whether they can succeed or not on their other claims. It's would a judge ever grant this claim? And for the reasons we point out in our brief, no, because you can never return to the parties to the status quo without unfairly prejudicing my client.
At this point, it's not just a matter of giving back the $300,000 because you also have improvements, we have changes, we have a lease, we have a lot of time that's gone by.
Exactly, Judge. In the decade plus that this contract was executed, my client has spent a significant amount of time and resources developing the land.
Paying the taxes, right?
Yeah, and I'm sure as your honor is aware, $300,000 in 2012 is not what it is in 2025. So he would also lose out on all the appreciation in the land.
And didn't the plaintiff want to be put in the same position now? He wanted to be named as like the landlord or
if you actually look at the proposed amendment complaint, they want the entire deed to the land back, as well as to be put into privity of contract with the solar company, which I don't even think a court would have the ability to do. So for all those reasons, we don't think that the court should ever have allowed this claim to proceed. Unless your honors have any more questions, we will rely on
Questions, counsel? Thank you.
Thank you so much, Judge.
Good morning, your honors. May it please the court. My name is Christian Kleps. I'm appearing on behalf of the plaintiff respondent. I would like to address in turn the appellant's 3 points, starting with timeliness. The appellant is mischaracterizing our meeting of the minds argument as a mutual mistake argument in an attempt to attach a statute of limitations to it. The fact of the matter is, if you look at the case law and if you look at the secondary statement of contracts, there is a distinction between meeting of the minds and mutual mistake. That distinction is as follows. For meeting of the minds, there is a realization that there was never an agreement formed between the parties, whereas with mutual mistake, there was an agreement formed between the parties, but it is avoidable due to an error in the transcription or the execution of the agreement.
Can I ask you this, the cause of action that you sought leave to amend the complaint was rescission. Is that correct?
Yes, sir.
That's the cause of action. Do you agree with counsel that cause of action accrued when the contract was signed on March 25th of 2012?
No, your honor.
Why not?
Because I would say that the document that was signed was not actually an agreement because there was no meeting of the minds. You
want to rescind a contract that doesn't exist?
I want to rescind the document because there is no contract.
So you could go back 100 years theoretically. You could do this 100 years from now.
Well, I mean, you could put it that way, but the fact of the matter is, if you look at the statute of limitations that's at issue here, CPOR 213, subsection 6 lists mistake as a doctrine to which it is applicable, but it does not list meeting of the minds. A statute of limitations essentially acts as a bar, essentially making sure that parties will remain bound to a contract. But how can a statute of limitations ensures that parties will remain bound to a non-existent contract?
If your client learned of these land rights that they're leasing it out to solar companies 20 years from now. He could come in and say, hey, I thought we were talking about fracking. There'd be no statute of limitations problem there for you on a rescission cause of action?
Well, I suppose that would be a question better suited, not for an attorney, but for the legislature. In terms of when a statute of limitations should apply, if at all, to a meeting of the minds issue. So turning to the record, there are no documents in the record that shows that my client set forth mutual mistake as a cause of action for the amended pleadings. So that argument is not properly before the court. All the meeting of the minds case cited in my brief, 2 from this department, 1 from each of the other departments, all the courts in there held as follows, that there was no meeting of minds and thus no contract. And none of these courts ever mentioned the term mistake, let alone the doctrine of mutual mistake. This demonstrates that the doctrine of meeting of minds is distinct from mistake and can stand on its own as a legal doctrine. I mentioned the second restatement of contracts before. It distinguishes between meeting of the minds and mistake in 2 separate sections. There's chapter 3, formation, effect of misunderstanding. That's meeting of the minds, whether a contract was formed at all. And then mistake has its own chapter in chapter 6, and that deals with voidability.
About the fact that you're looking for an equitable relief here, rescission, and arguably, as counsel indicated, that there's a breach of contract claim wherein if you're successful on that, you'd be entitled to significant sums of money. So that's your relief there. So there's no equitable relief here.
Well, Your Honor, the situation is that this is our argument in the alternative. It's still our primary argument that there was a contract, that the appellant is in breach of it.
We want to rescind that contract, though. There's a contract, but no, we don't want to. We don't want that contract. We're going to rescind it. There was never a contract.
Well, the issue is
you're trying to enforce a contract that never existed.
Well, the issue is the appellant is trying to have it both ways. This is our argument in the alternative that there was no meeting of the minds, because if the court accepts.
Is the appellant trying to have it both ways, or are you trying to have it both ways? You're trying to wedge in your rescission claim now to have it both ways.
Well, I would turn the court's direction to the September 18, 2024 deposition, where appellant Brandon Brady admitted 3 times that if he had known my client's interpretation of the reservation clause, he never would have made an agreement with my client. So he essentially admitted 3 times there was no meeting of the minds.
But that's because he's saying it was for the mineral rights and not for the solar panels. Right? I mean.
Excuse me, Your Honor, but I believe if you look at the record, pages 55, he was asked that if he knew that the agreement was for 50% of rents, claims, and royalties, not just mineral rights, that he never would have agreed to that.
So I'm wondering if your argument regarding failure to meeting of the minds, no meeting of the minds, whether that swallows up the doctrine of mutual mistake. What mutual mistake would be is, oh, I thought the contract meant A and they thought the contract meant B, which again sounds a little bit like what we have here. And I'm not surprised that's what the defendant's pointing out. But if you could say, oh, there's no statute of limitations as long as there's no meeting of the minds, why wouldn't everybody do that? How would we ever get the doctrine of mutual mistake? Everybody would just say, no, it's no meeting of the minds. It wouldn't exist as a separate doctrine. Do you understand what I mean?
Yeah, yes, I do, Your Honor. There is a reason why many courts mention mutual mistake and meeting of the minds in the same case. But that's because when there is a mutual mistake, it is a failure to represent a meeting of the minds that had taken place. And the reason why we have meeting of the minds as a separate doctrine is because the legislature has felt that we shouldn't use statute of limitations to bind parties to agreements that they never made in the first place. And I actually have a case in which this department defines the distinction between the 2 documents. I can read a relevant quote from it. This is from.
It's cited in your brief, counsel?
Actually, it's not from my brief, Your Honor. Is that still permissible? Or?
Oh, no, just tell us what the cite is. Instead of just reading from it, tell us what the case is first and the citation so we have it.
Okay, it is Nowicki versus Esperson. And it's 63 AD 3D 1696, 4th Department, 2009. And in that case, this department talking about mutual mistake, says the idea is that the agreement, so there was an agreement there, the agreement as expressed in some material respect does not represent the meeting of the minds of the parties. So it's not that there wasn't a meeting of the minds, it's that there was a meeting of minds in place beforehand, but the agreement as expressed, as transcribed, does not represent it. That is the error that is in place.
Anything further, counsel?
I would just like to comment on waiver and then one additional point, and then that would conclude my argument. So for waiver, it is the respondent's position that that is more suitably left to discovery, as it is a factual issue. But if this court would like to deal with that issue, I would just say that the record on, page 48, there is a letter from my client's former attorney, Rachel Skura, in which he indicates that the appellant counsel never informed her that the appellant had a different understanding of the reservation clause. And so my counsel was not aware of the issue years beforehand. And in fact, when my client received a letter in 2023 that the appellant was not going to pay rents, he took immediate legal action. So therefore, there was no waiver. And finally, I would conclude that this department in Omni Group Farms, Inc. Versus County of Cayuga, 199 AD2D 1033, 4th Department, 1993, quoted the Court of Appeals in Loomis, finding that prejudice is not found in mere exposure of the defendant to greater liability. And that's exactly the situation here. We're dealing with a party trying to exercise a CPR 3025 right to freely amend pleadings. This does not prejudice the appellant because the appellant is still free to raise these issues at any other time in the litigation.
Thank you, counsel.
Thank you.
Case 771, Park Avenue Estates LLC versus City of Buffalo. Justice Nowak is recused in this case. Ms. Queen, can you hear us?
Yes, Your Honor.
And we can hear you very well. Please proceed, counsel.
Good morning, and may it please the court. My name is Steven Salcedo. I represent the appellants in this case. They are the owners of the building at issue in the Cobblestone District in the City of Buffalo. And I'd like to start by making absolutely clear that my clients are not challenging in this appeal any discretionary decision-making by the commissioner or by the city. We're not challenging whether the building can actually be saved, whether the commissioner did a thorough analysis of the building before ordering a stabilization. We're not challenging any of that. We're arguing only that she did not have discretion to order a stabilization.
This is a mandamus proceeding.
This is mandamus to compel, yes.
Before you get too far in the argument, could you just clarify some issues? As you know, there was a fire that destroyed some of the buildings within one property, maybe 4 out of the 5. It caused some damage to the other one. The city has spent $395,000 plus to stabilize these buildings now. The buildings have been stabilized. Your client wants to demolish them. If we were to agree with you on the mandamus, would we order the city to demolish buildings that they have now spent close to $400,000 to stabilize? Because the buildings are no longer a threat, right? All this money's been poured into them. Would we grant that relief now?
In my view, Your Honor, this is all one building. There are references to multiple buildings throughout the record. There are also references to them being a single building. I think the court can take judicial notice of the fact that this is all one structure. Everything is connected.
2 addresses.
Yeah, 2 lots, 2 addresses.
You agree that the buildings have been stabilized?
That's not in the record. I don't personally know whether they've been stabilized or what it would even
Agree that
mean.
the city spent $400,000 to stabilize them for that purpose?
They spent $395,000 for that purpose. I agree that was the purpose of hiring that
Get that
contractor.
money from your client, but let's say that money served its purpose and the buildings are stabilized. Your client's request was for an emergency demolition of these buildings on the grounds that they were a danger to the public, right? That was, these are.
No, Your Honor, just to clarify, my client's request was to demolish these buildings because that is what is required by section 113-15.
No, I get it.
Emergency or not. It's about the damage to the building. Does it meet that does it exceed the 50% threshold in the statute? And is it a wooden building?
But
So whether-
the fire, damage from the fire, should it be demolished? Or should it be rehabilitated? Those were the two arguments. The city wanted to rehabilitate them, stabilize them. Your client wanted to demolish them. In the meantime, your client lost below. Now the city has stabilized them at their own expense. If we agree with you on your mandamus, on your arguments on the code and so forth, with the heavy timber being wood, would your client be able to demolish those buildings?
Yes, Your Honor, because that is what's required under the statute. It's very clear. Every wooden or frame building, if it meets that 50% threshold, must be taken down. It shall not be repaired or rebuilt, but must be taken down. And so at that time, we say that based on the record, it's clear this building was damaged far beyond
If it's
50%.
not damaged to that extent anymore.
This court has to look at.
Is it moot now, given the rehabilitation efforts that have been undertaken?
No, this court needs to look at the state of affairs at the time this case began. Otherwise, the city's illegal act of stabilizing the building would deprive my clients of the remedy that they were entitled to at the beginning of the case. I don't think that can be.
And I apologize for, I'm just trying to figure out what the, what's still at stake here. If the city not only stabilize it, but build an entirely new building, brand new, state of the art.
If the city had what?
Instead of stabilizing it, they actually built a new building.
Okay.
Would you say, because your clients were entitled to demolition, when this action was commenced, they should be able to demolish this brand new building?
Obviously, that's not this case, but I'll answer your question. I think that would be a different situation, and perhaps we don't prevail there because the statute speaks of a building. And so if the building that the city has erected in this spot is not the building that was damaged beyond 50% of its value, if it's not wooden, then maybe we're not within the scope of section 113-15.
So you make this.
Okay. It sounds like the court is well aware of my arguments about whether this is a wooden building. The city's argument was at first that timber is not wood. My understanding, my reading of their answering brief is that their position has changed somewhat, and now they're making a distinction between a heavy timber building and a wood frame building, and saying that, well, under the industry parlance, these are two different types of buildings. The statute encompasses wood frame buildings only and not heavy timber buildings. The problem, of course, as I lay out in my briefs, is that the statute doesn't speak of wood frame buildings. It says wooden or frame. And so for the city to prevail in that argument, this court would have to rearrange the statutory language and delete that word "or" at the very beginning of it. And of course, courts don't do that.
Supreme Court didn't get to the merits of your argument. Supreme Court instead said your client failed to exhaust administrative remedies. The city, to my knowledge, hasn't identified what those further administrative remedies would be. So you say that was an improper basis to dismiss your petition?
I believe the city, go ahead.
So would we, if you're right on that it was improper to dismiss for failure to exhaust administrative remedies that don't exist, would we not then require the city to answer the petition, and then the court can eventually rule on the merits of your argument on the city code?
No, Your Honor, and I point the court to the Miranda case that was decided, maybe it was in the early 2020s. I was actually a part of that case. And if the positions of the parties are clear, based on the city's motion to dismiss, the respondent's motion to dismiss, and there are no unknown facts that would affect the outcome, then there is no reason to send it back for the city to answer. It would be sort of a pointless exercise merely to delay the case. And there's no need to do that in this situation because the parties' positions are clear. And our position is that the court doesn't need any additional facts, that everything the court needs to resolve this dispute is already in the record. And I'd like to just clarify that my view of this case is that the city has clearly stated what the remedy is that it thinks we should have exhausted. The city is saying that we should have gone to the preservation board and asked for a demolition permit. I think that's throughout the record. Even Supreme Court below specified that in her oral decision. And that administrative remedy has nothing to do with the $395,000. that remedy, that exhaustion argument is a defense only with respect to our request for a demolition. Because they say, well, you can't get a demolition here, you should have asked for it through the preservation board. So it was, sorry, sorry about that. So it was inappropriate to dismiss the entire petition based on this exhaustion argument, because one of the arguments we were making is we can't be liable for this $395,000. And exhaustion is just not, it's not relevant to that point. So for the court to dismiss the entire case on that basis was improper. With respect to demolition, though, we recognize that exhaustion is potentially an argument that prevents us from getting a demolition from this court. And as I set forth in the briefs, the reason that we did not have to exhaust that remedy, the reason we did not have to go to the preservation board is because there is an exception in the preservation board legislation. It's City Code Section 337-28 that creates an exception for emergency situations. When there is an emergency to health and safety and life, obviously the building owner doesn't have to submit an application to the preservation board and wait for a hearing and go through that entire process. And that's explicit in the statute. And here the commissioner did declare an emergency on paper and writing to my client back in July of 2024. So we have an emergency, we fit within that emergency exception to the preservation board requirement. And the statute, section 113-15, is clear that the building shall not be repaired or rebuilt, but must be taken down. And so we're asking the court to require the city to comply with this language and allow my clients to demolish their building. Again, I believe the entire structure, everything is connected. Yes, it's on two parcels. It has two addresses, but it's one structure. I think that's one building, and this court should allow them to demolish the building.
Would it be more favorable to you to make it with the 110? I think it's 110 is the one that's been damaged, that building. Is that the address of the one that's really been?
So if this court disagrees with me that it's one building.
If it's more than one building and it's 110, the value of the 335, 395, what it was to restructure that or bring it into safety compliance is greater than the one half of the amount of the value of the building. The one versus the whole building. So if it's the whole building, maybe it's a question of fact of whether or not it meets that one half threshold. But if it's just maybe the one building, then maybe it has.
I agree. It's a much simpler case with respect to 110. There's a document in the record from the Buffalo Fire Department that the damage was $1 million with respect to 110. And 110 was built all at one time back in 1852. I believe it's page 225 in the record. It's a news article submitted by the city that had a paragraph on the history of this building that at a minimum, 110 is a single building. It was all built at the same time, used as a bakery, and then a foundry was added onto it, I think a few decades later. So absolutely with respect to 110, we meet that threshold. But with respect to the entire building, we also meet the threshold based on the record. And I don't think there's any disputing that. And that's because we have an assessment from the city of the entire, both parcels for condemnation purposes, valuing this building before the fire at $230,000. It's already.
You're saying the assessment equals value?
So there is information in the record about an assessment for tax purposes, and that was $785,000. And then the city appraised it for purposes of eminent domain. As you all know, eminent domain proceedings are pending with respect to this property. And that assessment was $230,000. So first, I think it should raise eyebrows that for tax purposes, the city says it's worth $785,000. And then when it comes to taking it from my client and giving him just compensation, they say it's worth $230,000.
And then they spent twice as much trying to stabilize the building that's worth.
Right. So if it was worth $230,000 and they spent $395,000 to stabilize it, we're way beyond the 50% threshold. This is over 100% of the value. Yes.
The city has condemned this property and prevailed here in this court a couple of years ago. Yeah, but they haven't commenced an Article 4 proceeding to acquire title yet. Does that have any effect on your client's rights here? In other words, the city has condemned it and is on the path to acquiring title. Can your client, until they acquire title, do whatever he wishes with the property, including destroy it? Or does the city have no rights in this property that they have their Article 2 petition has been granted? Does that not give them any rights to this property?
My clients?
Does the city until the city acquires the property through eminent domain, Article 4, can your client do whatever he wishes with his property until then?
I wish that were true. In the city of Buffalo, I don't believe it is lawful to simply demolish a property without any kind of permission from the city of Buffalo.
No, I'm saying if you were to prevail in this proceeding, you have the commissioner ordered to perform her job, which is to demolish buildings under certain situations. You can do that even though the city's ultimately going to be taking title to it?
Your Honor, the city does not have title to the property. My clients own the building. They're the legal owners. And so that's the state of affairs. The city does not own it. To clarify, what we're asking the court to do is to order the city to allow my clients to demolish the property. I mean, my clients might well do it in a cheaper way than what the city would do. If the city did demolish the property by order of this court, then perhaps they would come after my clients and say, well, you have to pay for the demolition of your property. And so my clients should have the first opportunity to do that. So I did want to clarify that. And I also wanted to clarify, Justice Montour, I was talking about the assessment for tax purposes and the assessment for eminent domain purposes. Even if we use the $785,000 tax assessment, still the $395,000 is more than 50% of $785,000. It's close, but it's more. And further, this statute directs us to look at not the value of the land plus the foundation plus the above ground portion of the building, which is 785 or 230. That's the fee simple value of the property. The statute directs us to look at the value of the building exclusive of the foundation. So if the fee simple is 230, the building exclusive of foundation is much less than 230 by the city's own estimations. If the entire property of the fee simples were 785, above ground, exclusive of foundation, exclusive of the land, it's less than 785. So I don't think there's any question about the 50% threshold in this case.
Thank you, counsel.
Thank you very much.
Counsel Quinn?
Good morning. To address that last point, I guess, first. So all of that argument about the valuation, about the buildings, about the damage that Justice Montour and Justice Whalen really were getting to, that is why the court cannot order a demolition here. All of that would have to be fleshed out during a hearing, after the chance to answer, through whatever type of evidence would be set before the court. And I would note to Justice Lindley's point, I mean, that is also set forth in 113.15 in an additional procedure which contemplates a surveyor go out on behalf of each side, the city and the owner, to do a survey. And if those individuals can't agree on that information, that there would a third surveyor be appointed, and that person would have the say. So all of that is to address sort of the last point first, which is even if the court doesn't agree with us on our other arguments, I don't think there's any basis to order that these buildings be demolished in this instance. Counsel makes a representation that 110 is one building. In fact, there's evidence in the record, including the sworn affidavit from Commissioner Amder, and also any number of things that indicate they are not, in fact, one building. So for those reasons, we submit that it really is, the relief they are seeking, they want to call this a mandamus proceeding, but it really is not. All of this is imbued with discretion. And when you look at the purpose of the statute, which includes the historical nature of it, which includes the commissioner's rights and obligations and sort of authority to look at any number of factors in either stabilization, demolition, or otherwise, all of that really makes this sort of what we would argue is an arbitrary capricious standard, not a mandamus to compel it. I don't think that's appropriate here. Petitioners cite to no other case where that standard was applied to this particular statute or an instance where it even occurred. Really is they're trying to fit an argument, which, as this court well knows, they want to demolish this building. As of recently, as of October 10th of a few weeks ago, the court rejected another attempt to demolish this building through a separate argument, which we do argue in part has, at the very least, informs the history of this dispute. But we do argue that it should sort of have some type of res judicata collateral estoppel type arguments. That's not our main argument. What we really start with is that they failed to exhaust the administrative remedies, and that was what was decided by the trial court.
What was the administrative remedies here? Failure to go to the preservation board to seek permission for demolition? Is
That
what-
was the first, yes, Your Honor.
And they, I mean, they've since done that and it was denied, but at the time that this petition was filed, they hadn't gone to the preservation board. So that's what they should have done in your view, and that's what the judge below held.
Yes, Your Honor. Because that is to get to
Counsel
the.
argues though that there's two ways to get demolition. There's one in an emergency situation where there's fire or other damage to the property. And there's all these, it's under the city code, I think 15-113. And then there's another way to do it when there's not damage. You just want to demolish a building of historical significance, you have to go to the preservation board. Two different avenues to get to destruction under different circumstances. They say they don't have to go to the preservation board because they're going down this other road. And they're entitled to it under this other road based on the argument that heavy timber is wood.
So that other road we would submit is the sole province of the commissioner. So that is the commissioner's decision as to whether or not an emergency exists. And if an emergency does exist, what remedy or relief is appropriate, whether or not that be stabilization or demolition or something else. So that is not something that a petitioner or an owner can avail themselves of, just saying, we think that there's an emergency, therefore we are choosing this other route. That really is a decision made by the commissioner, and that's where you get to an Article 78 standard and the deference that is afforded the commissioner's decisions to interpret the statute, apply that statute to the facts of the case, and ultimately come to a determination as to whether or not stabilization or demolition was appropriate in this instance. And I think her determination was well set forth in the record, in the affidavits, the correspondence as to how she reached that decision. And I think ultimately, then that decision was acted upon and the buildings were stabilized. To get to Your Honor's point, that really does make this all a moot issue. The buildings have now been stabilized. I would submit that it would be an absurd result in this instance or the hypothetical that Your Honor provided as to whether or not the city put a new building on top of an old building or whatever distinction council was trying to make. The facts have changed. So the circumstances surrounding the initial determination have in fact changed. The city has submitted substantial resources to stabilizing this building. We are now years later. There have been no, additional incidents at this building. So we then look to what are the next steps here. And I would submit that whether or not an actual proceeding has been commenced under the eminent domain proceeding, I can represent that, we are looking into potentially commencing it very soon. So it is likely that a eminent domain proceeding will actually be commenced prior to the determination by this court. So all of these things are changing fluid circumstances, which I would submit warrant, the petitioner is going to have their day in court on any number of these things, but it's inappropriate for this court to find, as a matter of law, that the city was required to demolish this building, because that is what they are arguing, that the city had no discretion and that based on this statute, the city was required to demolish this building. And
If the demolition is moot, the cost of demolition certainly is not. The city is seeking reimbursement from Mr. Carr for the $395,000. That's still at issue, right?
I believe it's still at issue. What ultimately becomes of that, I don't know, particularly because you do have this eminent domain proceeding out there as well. So, I mean, the city is coming from this from any number of angles in an attempt to, we would submit, force the owner to do what they're required to do. But all of this is going to play out in courts and elsewhere. Finding that the city has to, despite all of these things, despite all this effort, go in and demolish this building, it just would be I would submit, an absurd result. I don't think it's warranted here. And in particular, because the specific argument that they're making and its application to this building. So to get to the sort of the timber versus wood versus frame structure, I don't know exactly what petitioner is referring to with our arguments changing. I don't believe it has changed at all. If it seems that way, I'm not sure what is being referred to, but ultimately the commissioner made a determination that based on her experience, based on her understanding of what frame versus timber means in the context of construction, which she is an expert on, this is what she does, that is not what this statute was about. And now I think petitioner is trying to sort of say, well, okay, there's that or in there too, wooden or frame building. And I think it's important to note that if you look at the actual title of that provision, 11315, it just references frame building, which I think really gets to the intent of it. But putting that aside, and putting aside the history, which we also submit really gets to what the purpose of that statute was, and even putting aside what timber versus frame means in the context of fire prevention, safety, and all of the things which underlie this statute, even putting that aside, if a normal person went out and looked at that building, they would not describe it as a wooden building. It is a brick building. It is a building made of bricks. So to the extent that they want to say that this is a wooden building, that they can sort of prevail under either, it doesn't pass muster. If you look at the building, it is clearly a brick building. It has a brick facade. All of them have brick facades. There are wooden timber, heavy timber aspects of it. And the commissioner, I think, goes to great length to explain why that is not really what the statute is talking about.
Is it that heavy timber is not as flammable as ordinary wood?
That's correct, Your Honor. Yeah.
Well,
It's really
I guess
very
your
different.
argument is that the commissioner is an expert in this, and the agency is entitled to some deference with how they interpret terms of the city code. And we should afford them some latitude in how they interpret heavy timber, wood, and when this provision would be triggered.
I think that's accurate. That is certainly part of our argument, Your Honor.
Anything further, counsel?
No, Your Honors, I appreciate the time.
Thank you. (772) Horning versus JB Wise Professional Buildings, and 772.1 Horning versus Millard. We'll call both cases. Mr. Pierce, proceed.
Good morning, Your Honors. I just want, Alan Pierce from Hancock Estabrook for Appellant Thomas Horning. I just want to confirm on the calendar, it's the case involving Mr. Mark Bonner's motion to dismiss is the first of the two listed. So I'm going to address that case first.
That's fine. You should address both those. You pick the order of the cases, but address both, and then we'll have Mr. Devendorf address both also.
All right. Well, in that regard, then, Your Honor, I'm going to start with the earlier action against Eastern Market and Mr. Millar, because that's kind of that's the real basis here.
Very good.
So as to that action, I think this appeal really boils down from the trial and the findings of fact and conclusions of law, at least as to Eastern Market. And I'm going to very briefly talk about Vina Bonner and Mr. Millar, who have not appeared on this appeal. But as to Eastern Market, this appeal really comes down to the question of whether or not Eastern Market had a 40% interest in this LLC. At the time of the vote, May 1st of 2018, to sell the property that Mr. Horning deeded to the LLC as his capital contribution. So
at that point in time, Eastern Market had only contributed of their 125,000, 68,000 plus.
Yes,
Correct.
yes, and it's stipulated to.
But
Agreed.
if taking it one step further down to the waiver portion, there's the market wants to get out, right? And both Millar and Mr. Horning agreed to let.
They did. There was a signing of an agreement to let them out, but they never got it.
Pay the 68,000.
Right.
Reimburse.
They never got it.
$68,000.
So there's really,
isn't then Mr. Horning at that point in time agreeing that Eastern Market was a member?
I don't think so, Your Honor.
If you were never a member, are you saying that, then you don't get out?
I don't believe so, Your Honor. I think there's a difference between, and the withdrawal document that Mr. Horning signed was years before the vote. So, well before the issue of interest and had they made their payment came up. So, I mean, there are two arguments. One is that they didn't have to put their 125 in at any particular time.
There's no date in the operating agreement.
There isn't, but the only in exhibit C about capital contributions, the only persons whose contribution is at all got a timing element to it is Mr. Millar's that's listed there that after Eastern Market. And again, that reinforces the idea that Eastern Market was supposed to make their capital contribution like Mr. Horning did at the very beginning. And again, we stipulated. So
Can
I
I just
think
ask you this, Mr. Pierce, with respect to capital contributions? There are three members of this LLC.
yes,
Your client, his capital contribution was the real property.
yes.
There was a mortgage on it from the bank. Do we know what equity was in the property? In other words, what's the dollar amount of his capital contribution? We know that Mr. Millar put in nothing. He claimed 15 to 20 at trial. He had no receipts. He had zero. We know Eastern Market eventually put in 60 some odd thousand. Your client seemed to put in, if my math is right, the property sold for $335 years later, right?
Yes.
The mortgage at that time, the balance was 167, I believe, somewhere in there.
I'm probably wrong. I was thinking more in the 125, 135 range, but somewhere in there.
So your client, what was his financial contribution we put in dollar amounts?
Well, it would be the difference between a sales price and the mortgage.
Right. So a lot of like 100 some.
Quite a bit. I at one point, there was some talk about it might have been less than the 125 that each of the other two were going to put in, which is why Mr. Horning ended up with 20% interest and the other two entities, Millar and Eastern Market, got 40% each. But there was no specific dollar amount of equity determined as to the equity in the building when Mr. Millar transferred.
When it was sold, it sold for 335. And
Yes.
he was owed on the bank. The mortgage was 167.
Yes.
So his equity, well, it wasn't his at that point, but
right.
There was a lot of money in that.
There was.
So of all the three people who were involved in this, your client puts in by far the most money.
Yes.
By a wide margin. Millar puts in nothing. Eastern Market puts in 64. They're supposed to put in 125.
Yes.
The business doesn't go anywhere.
Right.
Nothing happens. Nobody's making money. Millar comes out unscathed. He gets sued for fraud by Eastern Market. And then he settles that lawsuit.
With the proceeds from the sale to Vina Bonner.
84. So Eastern Market gets all its money back plus 9% interest or some high interest rate. They're made whole. Millar doesn't lose anything. On a losing proposition, your client is the only one who lost, and he lost everything he had.
Absolutely.
And
he's the only one who complied with the agreement, and he got nothing. He got nothing, and he lost everything he had. Which is our view of, there's no way these findings of fact and conclusions of law make sense based on the facts and the agreement.
Millar satisfied a lawsuit filed against him in Queens for fraud.
Yes.
By a fellow.
Out of the proceeds.
He settles that for fraud.
Yes.
In respect to this endeavor. And he settles that, and how does he pay that judgment? With the only money from this LLC, which came from your client.
Well, because he and Mr. Eisenberg from Eastern Market basically collude to take care of that and take the money out of Mr. Horning.
And that's, in your view, a breach of fiduciary duty to your partner.
Yes.
He robbed Peter.
Breach of fiduciary.
Robs Peter to pay Paul.
Yes. Absolutely. This is a horrible, horrible result here of what happened to Mr. Horning. And then we
ultimately had a claim against the $70,000, right?
Right.
At the end,
which then got, and before I turn to the case against the Bonners, as I would call it, the Bonner action, I just want to add about Vina Bonner in this Millar, Eastern Market and Vina Bonner lawsuit, the 2018 lawsuit, that about the personal property.
Tanning bed.
The tanning bed.
Yeah, the tanning beds and related equipment. There certainly was sufficient evidence here and non-jury trial, sufficient evidence here for this court to award Mr. Bonner the value that was basically undisputed at trial. It's about $81,000.
That's basically, it was an estimate. It wasn't admissible form, was it?
Well, the document was admitted. It was admitted by Justice Gilbert and Mr. And in fact, the court itself credited in the findings of fact credited Mr. Horning with testifying consistent with the estimate, which came.
But then again, that estimate didn't consider anything as far as the damage, water damage, mold, anything else. Didn't consider that, just consider what he paid for them, basically, right? Wasn't it just?
I believe that's somewhat, yeah,
Right,
I believe
so
that.
he didn't really prove the damages there. You know, he submitted the receipt for buying it, but then there was nothing considered with respect to the value of what the damage was.
Well, it certainly was more than $1, which is what he got.
Yes, exactly.
Certainly more than $1. Anyway, so let me turn to the Bonner action. And this is an action, this is one of the most unusual circumstances I've ever seen in almost 40 years, about 40 years. So Justice Gilbert orders the plaintiff, Mr. Horning's counsel, then counsel, to commence this second lawsuit because of the sale of the property and then, the LLC authorized, that's the heart of that first case, sale to Vina Bonner. Well, Vina Bonner, of course, turned around and transferred the property to this LLC that included herself and
brothers and a brother,
a bunch of other family members.
Horning had nothing to do with that.
Right.
What happened to Horning?
Wow.
Yeah. He had no percentage of that.
He's gone because he objected to the sale to Vina Bonner, and then Vina Bonner transfers it to the LLC that includes herself and family members. And then eventually she's found in contempt of court.
She sells somebody else. Right?
James Bonner puts up the 70 grand to avoid contempt against him because he's part of that sale. And the court orders there'll be no further sales. And then they turn around and sell it to a third party after that. Again, what a bizarre set of circumstances, but it gets even better. In January of 2014, after the trial court rendered the findings of fact, conclusions of law in the Millar and Eastern Market lawsuit, says in this 2022 lawsuit against the Bonners, well, I rendered a judgment and findings of fact and conclusions of law in that case, but that's not binding on the issues in this case. By the time James Bonner makes a motion to dismiss or in the alternative summary judgment, and it's heard and decided in May.
Was it Mark Bonner who made the motion?
Mark, I'm sorry, which one did I say? It's Mark.
You said James, right?
I'm sorry, it is Mark.
I remember
Mark
that
makes the
name,
motion.
but
So
connection.
by May, 5 months later, the judge uses his findings of fact and conclusions of law in the Millar action to dismiss the other action and throw out the escrow of $70,000 that Mark Bonner didn't pay. James, I think that's why I was confused. James Bonner paid the $70,000 in escrow. So now there's no money sitting there available to Mr. Horning.
Would the money be available for Mr. Horning is the dollar he was awarded in nominal damages from Judge Gilbert, right?
Yeah.
I mean, so you need to have us adjust the damages for the conversion, Miss Bonner, or however, you need more than $1 for all this other stuff to make any to be worthwhile.
Yes.
Didn't they agree though also that the Bonner action would be against the $70,000?
No. I mean, it was there as some security, but I don't think there was ever any specific agreement as to what it was for. And in fact, the short answer is in the Millar action, we believe this court should reverse and you should award the proper amount of damages against each of the 3 defendants that Mr. Horning is entitled to. And it's a substantial amount as the Eastern Market and Millar and less.
I'm more sympathetic on those. With Bonner, the issue of damages, we have this email from another individual who's estimating the value of all these treadmills. Everything seems like rank hearsay. That's a problem that I would have, that I see you having to overcome to prove damages there. You didn't call an expert, just an email, but on the others, with respect to breach of fiduciary duty, that seems to be the strongest argument. In the memorandum of law, I know you weren't a trial lawyer, in the memorandum of law, that's right at the end of the record, the plaintiff's lawyer seemed to abandon the breach of fiduciary. I didn't see any arguments about that. It was a breach of contract. You didn't put your capital contributions in, all these different things. Can we get to this breach of seems like a strong breach of fiduciary claim, even though it wasn't argued in summation.
I think you can, Your Honor, because specifically because I'd have to look back at Mr. DiMartino's post-trial document. I don't remember him waiving it or
He didn't
abandoning it.
expressly. I don't mean to say he expressly.
But the court, in its findings of fact and conclusions of law and the judgment, dismisses the breach of fiduciary duty claim. So clearly, the trial court thought it was still in the case.
Yeah.
So
it's
submitted-
preserved.
It was preserved. It was in the case. The judgment specifically dismisses it. So I believe it's in the case and it's an appropriate avenue for a judgment here. And as to the second action, I think it should be reversed. We had a 180-degree turnaround by the trial judge as to what was the effect of the findings of fact in Millar. And that case should be back on the docket and it may be irrelevant depending on what this court does. But I think the $70,000 escrow, I mean, if the money, it should not have been dispersed. I haven't seen an actual document or anything that says it was dispersed, but I'm assuming it was, but I don't know since I'm dealing basically with all pro se people in that action. Thank you.
Thank you, counsel.
Good afternoon. Your Honor, it please the court, John Devendorf, Barclay Damon. What I'd like to do is begin with making sure the court appreciates what the three claims were against Eastern Market. One was a breach of contract claim saying you hid records from Mr. Horning or you manipulated transactions. There is zero in the record that substantiates the Eastern Market ever had any corporate records or had any.
It sounds like Mr. Millar was hiding from your client as well.
Absolutely, Judge. The second claim was that Eastern Market had failed to make its capital contribution. As we pointed out in the brief, there are a number of issues factually and legally that were appropriate for the dismissal of that case. They did make a $68,000 payment. There is nothing in the operating agreement that says when that payment had to be made by. Intervening in that was a decision made by Mr. Horning and Mr. Millar to accede to the request of Eastern Market to withdraw as a member. They agreed to do that by returning the capital.
Can I just ask you about that? So there's that withdrawal agreement.
Yep.
That was an effective withdrawal?
Well,
Eastern Market is withdrawn from the LLC at that point?
Here's the difficulty. We would say no because it was conditioned on a payment that was never made. It was
Because if the
conditioned
answer
on.
is yes, then Eastern Market shouldn't have been voting on sale.
No disagreement over that, but the dilemma was, and Justice Montour, I think, had a point I want to reinforce. That agreement makes very clear that Eastern Market was a member, makes very clear that it had made a capital contribution.
Yeah.
So,
But did Eastern Market representative ever sign that agreement?
Yeah, I believe it indirectly, Judge.
Where does Eastern Market, I know the problem for Mr. Horning is that he agreed to things that perhaps wouldn't in his best financial interest because he signed this withdrawal agreement, but this idea that Eastern Market's entitled to its $64,000 back on a bad investment. I don't understand that. It seemed to be settling a lawsuit from Queens for fraud against Mr. Millar, not Mr. Horning.
There were multiple claims in the lawsuit, and the reason that was part of the record in the trial, and I want to make a distinction, the only thing that was in the record in the trial is that there was a lawsuit and what the outcome of it was. There is no record, respectfully, in front of this court as to the Queens lawsuit, the reasons for the settlement,
right,
the actions taken by the LLC to bring about the settlement. The settlement and the lawsuit was against the LLC and its managing member.
Mr. Millar, but all the allegations are against Millar, nothing against Horning. The LLC was named. So
the LLC is party to the settlement.
Eastern Market sues the LLC and Millar in Queens.
Correct.
They settle that case for $80,000, right?
$84,000,
right.
Correct, Judge.
And then they collect that money from the sale of the property that was a capital contribution of Mr. Horning. But Mr. Horning paid, his capital contribution went to pay for the lawsuit that was filed against the,
I don't think you could look at it that way, Your Honor, because Mr. Horning also benefited from getting out from under his personal guarantee. You know, again, the context of all of this is that Watertown Savings Bank was heading to auction and about to auction this property off. Everybody was going to lose everything anyway. So for my client, either
not if there's equity in there. There was equity in the property, right?
there was, but
So how would they?
but from Eastern Market standpoint, Your Honor, either we were supposed to get paid $68,000 under the unanimous consent agreement plus interest, because that would be a breach of the agreement.
64,000, right?
68,000.
Oh, you said 16,000.
68,000.
Yeah, but you just said 16.
I apologize.
That's okay. I mean, maybe they're throwing out different numbers here. Wait a minute.
No. So either they've agreed that they have to pay us that money. They never did.
Right, and that was a foolish agreement that Mr. Horning, and there was no basis. This is a business venture that goes under. You're not entitled to your money back. But
Okay.
Mr. Horning agreed, I guess, in the signing that withdrawal agreement, he agreed to give him the money back for no legal reason whatsoever, and that's.
The fact that Mr. Horning now views that to be inequitable, or the fact that Mr. Horning did that notwithstanding representation of counsel, you know, and that's the other thing at trial. He had counsel at trial. He had counsel at the time of the vote that was taken. He's had counsel throughout this, whether it's a good deal or bad deal. That's for Mr. Horning to decide without.
Would you give me this much? The only person who lost anything in this venture is Mr. Horning, and he lost everything he had, plus his tanning beds. Nobody else, your client, it's credit to you, got all the money back plus interest. Mr. Millar put in nothing, and so he lost nothing. The person who lost all the losses on this venture, he got thrown onto one person. Doesn't sound,
what I would say, Your
sounds like a
Honor,
breach of fiduciary duty going on.
What I would say, Your Honor, is start with the premise that Mr. Horning agreed that my client should be repaid the $68,000 with interest.
True.
Why he did it, I would argue it doesn't matter at this point. We only got back the same money that they agreed to pay us 8 years earlier and never paid us. We didn't make anything more than they had already agreed to pay us.
Counsel, you mentioned during your argument a little earlier that that there was also an exchange for Mr. Horning also got out from under certain liabilities.
Correct.
On this, certain exposure.
Correct.
And that may have been the part of the calculation, but it doesn't really matter, is what your argument is. He had counsel, he agreed to it, and that's what happened.
100%. The only other thing I would say, Your Honor, is that the claim has become conflated as the appeal has progressed. The breach of fiduciary duty claim was actually saying that my client breached his fiduciary duty by supporting the sale. And what we had thought the record made very clear is that the circumstances of the sale were there was going to be an auction.
And also not paying off pre-existing debts.
Correct.
And the mortgage, wasn't the mortgage a pre-existing debt?
The mortgage was a pre-existing.
Right, and that was Mr. Horning's, but the value of the property far exceeded that debt. It's not like he was going to lose. There was equity there.
Okay, and my client only ended up getting paid the same money that the appellant before this court agreed to pay 8 years earlier. So he didn't make it. It wasn't a boon to my client. This was a payment that resolved out of a settlement agreement on a record that's not in front of the court at all. Nowhere in the trial was the settlement or the propriety of the derivative action or any of that challenged. And so to get to where counsel wants you to go, you have to conclude that the settlement was somehow improper. And I don't know how you do that without that case being before Your Honor. Mr. Horning was on notice of it. The entity was served. The entity had counsel, not me, different counsel. And they resolved those disputed claims in a way that essentially paid Eastern Market the money they had agreed to pay earlier. It's not inequitable, respectfully, Your Honor.
It's not what?
It's not inequitable.
Well, I will respectfully disagree with you on that. It's not inequitable given the fact that Mr. Horning signed that withdrawal agreement, which made no sense whatsoever. It's inequitable in the fact that two people invest in a business. One person doesn't put any money in, the business fails, all the losses are incurred by one person. Your client, thanks to you, got every penny back plus interest. That's where I think it's a little inequitable. I'm not saying it's unlawful.
Yeah.
I'm not saying that it should be reversed. I'm just saying, usually in a venture like this, one party doesn't absorb all the losses and another party gets their money back with interest.
Yeah.
Did you say,
Yeah.
that you didn't represent him during that proceeding, right? It was another attorney that did it?
Which proceeding?
Well, he said that.
I didn't represent the LLC. That's what I was saying. LLC had separate counsel. I've only been counsel to Eastern Markets. So the notion of, again, what I was trying to press to the court is that the settlement was arrived at with the LLC having independent counsel.
Mr. Kerwin.
What occurred between Millar and Mr. Horning and the LLC and Mr. Kerwin relative to that settlement, it is not at all within the record. So the settlement stands, and again, it's imperfect, and I understand Your Honor's point, but I resist the notion respectfully that we somehow made out differently than we otherwise would have. All they did was pay us the money. They agreed to pay a lot sooner.
Understood.
Thank you, Your Honor.
Thank you, counsel. Case 773, Tig versus King.
Good morning, Your Honors.
Mr. Webb, do you want to proceed?
Yes, Your Honors, and may it please the court, Brian Webb from Hurwitz Fine on behalf of the defendant appellants, Mr. King and D&H Excavating. Today we're here appealing the trial court's denial of our motion for summary judgment on both grounds. The first one being that plaintiff respondent was comparatively negligent, and part B is that we were not negligent in the accident of March 2019. I won't get into the specifics unless the court has any direct questions, because I believe the accident's pretty clear based on the testimony as well as the video of it. And I hope the video worked. I've never submitted a video on appeal before.
Worked for me.
Good. The main theme here is just the evidence to consider when evaluating a motion for summary judgment. Here we have clear evidence from my client, both through his testimony, through the affirmation submitted in the motion, as well as the video itself, that he was traveling under the speed limit in his lane of travel when plaintiff essentially lunged out into his path and was struck. In response, it's our position that the evidence submitted by plaintiff is inadequate to be considered at all in this motion, both because it's either contradictory on its face to the objective realities of the accident, as well as that it's contradictory to his own testimony when you compare his deposition testimony to also the affidavit he submitted. So it's our position just at its core that the evidence is that we were traveling fairly and reasonably under the law when he lunged out at us. And what he says just does not make sense, quite frankly, and it's at odds with the objective realities of the accident, and therefore we should be granted the relief requested.
I'll tell you what I saw in the video is the plaintiff was out on the side of the road near the fog line, going up and down the driveway, up and down the road. It didn't look like he was stretching to me to go for a run at all, but regardless, he's there on the shoulder of the road near the white fog line. Your client comes down the road, driving at a reasonable speed. Other cars earlier in the video, they see the plaintiff there and they reasonably go around. They go into the other, there's no traffic coming the opposite direction. They swerve around and keep their distance. Your client is driving down the road. Plaintiff is on the fog line or close there too, doing things with his arms, whatever he's doing. Your client, no cars in the opposite lane, no cars in front of him or back of him, maintains his position, hugging that same fog line and coming very close to the plaintiff. And his rearview mirror then hits this plaintiff. Whether the plaintiff lunged over the line or not, could not a reasonable jury look at this and say, your client, even if he didn't cross over the white line, he was negligent in not trying to avoid him a little bit more, swerving a little bit out of the way?
As to that, Your Honor, I've watched the video countless times, obviously. I think it's impossible to necessarily place where we are in the lane. I think it's fair. The only evidence we have to that is his own testimony saying that he was within his lane. But you can tell from his testimony, this is not the first time he's encountered plaintiff. He had driven past this area before, and every time he does that, plaintiff sort of, I don't know what you want to call it, goads him in ways and sort of harasses him, sort of, but he had never actually run into traffic before. This is the first time he ever ran into traffic. So he was not expecting him to actually enter the lane of travel. So I think he's reasonable in the sense that he's entitled to assume that someone's not going to jump out in front of him, even if it is this person that he has, I don't know, you want to call it a history with, so to speak. You could tell from the video that
if the plaintiff hadn't taken that step, and it shows maybe one or two steps, he didn't run in front of the vehicle, but he did make some movement towards, if the plaintiff hadn't done that and he stood exactly where he was, your client's truck would have come within how many inches of him? Like 5, 6, 7? And that's the part that I think doesn't make a lot of sense. He clearly saw him, and can't you just move over, hug the center line a little bit more? He was hugging the fog line right next to where the guy was standing.
I appreciate that, and I can't place exactly where he is in terms of inches and stuff, but I suppose he could have moved over to the left a little, but I believe that to be speculative, and again, I think he's entitled. There's some case law cited in there to assume that people aren't going to jump out in front of him, and whether you want to call it he jumped out in front of him or lunged at him or whatever, that is also part of this motion too. I don't think that part A and part B of the motion are necessarily mutually exclusive. I think it's absolutely indisputable that plaintiff himself should be considered comparatively negligent. I mean, he lunges at a moving vehicle. There's no doubt about that. As to whether or not my clients were negligent, I stand by the point that he is entitled to assume that people aren't going to do what plaintiff did in that instance, because plaintiff additionally hadn't done that on the multiple other occasions where something somewhat similar to this has occurred. So I think
the court denied the motion without prejudice. I mean, the argument about comparative negligence is still something that's preserved, still something that could be raised at trial.
Correct. This was just our motion for summary judgment on the issue of comparative fault. But I think that under the circumstances, it's completely indisputable that Mr. Tingu is comparatively negligent in this instance. I mean, you can see from the video, you can't do that. I think that every juror would know that you can't do what he did. You can't lunge at a moving vehicle while you're staring at it. This wasn't a surprise. He saw our client. He started, I don't know, gesturing at him, and then he lunges at him. That's obviously comparative negligence in my position. I appreciate the argument about it swerving, but I stand by the idea that he's entitled to assume that someone's not going to do what plaintiff did there.
We'll take a look at that, Mr. Webb. Thank you.
Thank you.
Case 774, Appellate versus Progressive Max Insurance Company. Proceed, counsel.
Good afternoon. I'm embarrassed that I asked for 15 minutes on this. I don't think that we necessarily need it. I don't think there are any factual disputes. It's just, what is the interpretation going to be of this New York State rules and regulation and the global case that did interpret it from the second department? Like I said, the facts are pretty straightforward. We have a person who gets into an accident and then gets insurance. The law is that what the the insurance cards say is when the inception starts, and it starts at 12:01 a.m. So it started before the accident.
Even if it's purchased, even if coverage is purchased after an accident.
Yes.
So let's say I'm driving home from work today.
Mhm.
I get into a horrible accident, all my fault, but I don't have any insurance. Call up my insurance agent and say, hey, give me as much as you can get me here. This is gonna be bad. I just ran somebody over. And they say, okay, sure, and they issue me a card.
You mean to tell me that carrier's got to cover for all the damage I did before I paid for this?
Yes, sir. And,
Okay.
and I'll use the reasoning that the courts use below in looking at the statutes. The burden is on the insurance company to not just blindly accept giving you coverage for that day. What they could have done is said, sure, you have insurance starting 12:01 a.m. tomorrow. Or they have to do their own due diligence and make sure that there hasn't been an accident that day before they issue that to you.
So if two parties want a contract, freely contract, that create an insurance policy and started at 4 o'clock in the afternoon. They want the ability to do that. New York State Legislature steps in and says, no, we're going to prevent you from making that decision. You either got to go 12:01 the day before, 12:01 the day after. New York Legislature wants to stop people from contracting. Let's assume that's true. You suggest that they did so by slipping it into Part 32, the regulation that's entitled Insurance Identification Cards. That's where the legislature put in the clause about not letting people freely contract to have insurance start at a particular time.
The insurance industry is one of the most highly regulated industries, and yes, that's where they put it because that's what it states. Coverage commences at 12:01 pursuant to the ID cards, and it shall not be some subsequent preceding date or inception or renewal date. And I understand the craziness of it. I understand that, but it is the law, and there is good reason for it. The global case that we cite, my client, Progressive, we know that case. We were on the other end of it. So that's why we know this and we understand. We never thought that we would have the opportunity that we would get the benefit of that rule. But in this case, we do. The vehicle that caused the accident was insured.
Can you, well, this argument is, the issue is, should it be going to arbitration? Can't the arbitrator resolve this issue? Why do we need to keep it in Supreme Court on that?
We don't. We would request that it be dismissed.
Well, can't the arbitrator consider all that and look at the rules and say, make a determination, was the vehicle uninsured? This issue that you're asking us to decide, look at the rules, when does it become operative? Can't the arbitrator resolve those? Maybe you'll win in that form.
I believe that they can, but because it is a question of law, we feel much better coming to here than we do with an arbitrator.
And whether there's coverage in the first instance is typically for the court, not for the arbitrator.
Correct.
Thank you, counsel.
Thank you.
May it please the court, Tim Bellavides for the plaintiff respondent in this case. I have mixed emotions about arguing this motion as a member of the plaintiff's bar because I kind of like the position put forth by Progressive Max in this company. I would love there to be an insurance in every case that I have where I have an uninsured defendant. That would be fantastic.
Tell them to go run out and buy insurance.
Exactly.
It's
a
commercial. Do you disagree with, what exactly does this New York regulation say about the timing of insurance? Is it
for me
black and white, as counsel says, or is there some oars in there?
No, you have to read the regulations, I think, in the context of, for me, the reading of that statute is basically, hey, look, you had to have an insurance ID card on you at the time you're involved in an accident to present that information, not only for purposes of the police and their investigation, but also for the other driver to handle the collision claims, to handle potential injury claims that you might have. There's a public policy in having an insurance ID card on you while you're operating your motor vehicle. I don't think it was ever intended for the state of New York, through its regulations, to go ahead and say, you know what, we're going to give you the opportunity here because your insurance company put 1201 on that card, even though you purchased it 88 minutes after the accident, the policy, we're going to force that insurance company to provide coverage. Even though on the declaration page, it says, wait a minute, policy is not effective at the later of 1201 or when you purchased the policy. And the regulation
be inconsistent with the regulations.
The policy might be. It might be, but for me, the policy is different from what the regulations say. The regulations, the purpose of the regulations are, hey, have an insurance ID card on you to present to the police and to present to the other driver for ease of resolving collision or injury issues that may later arise. And I think in this case, what appellant is asking you to do is basically say what you initially said, Judge Lindley, which was, hey, you can go out because your insurance company made a mistake on the insurance ID card, not on the declaration page. You can go out and purchase more coverage. That is not only ludicrous, it's unheard of.
You can get some coverage for millions and millions.
Absolutely. Depending on the severity of the accident, I'm on the phone with my agent and I'm going to talk about a meeting of the minds being devoured by a New York State regulation. What did we agree to as the consumer and the insurance company? Something very different than what New York State's going to hold us accountable to if we read the regulations as Progressive wants us to. And that makes absolutely no sense in contract law or in any other area of the law.
Thank you, Counsel.
Thank you.
Case 774.1 Morris versus Smith. We have 4 arguing today, correct? Very good. Counsel, proceed.
Thank you, Your Honors, and may it please the court, Andrew DePasquale, a co-appellant and attorney for the child. I will rely on my brief for any of the legal arguments, but I think one of the most important parts of my brief was the matter of Michael B.'s statement, and I wanted to expand on that. I will say, I know I don't have to ask for your permission, but feel free to interrupt me if
well, we will.
Okay, anything, I don't want to bring up anything impermissible here. Because I will be discussing my conversations with people in my client's life. So my matter of Michael B statement leaves off with it's July. There hasn't been much contact with dad. I did speak with my client on July 1st, where she says she hasn't seen her father in a very long time.
April.
Ms. Buntley, grandmother here, indicates that her last contact with dad, my client's last contact with dad was early April. Ms. Buntley had contact with dad on, I believe it was April 19th via text message, where he indicated that he wouldn't pick her up. And that was her last contact with him until this month. So I meet with my client in July. School starts September 3rd is the first day of school. There's the current order allows for dad to pick up my client every Thursday after school. So there's 4 Thursdays to start the school year. He doesn't pick her up on any of the Thursdays. October 2nd is the 5th Thursday, obviously 18 days ago. And that is the first time that my client had seen her father in a very long time. And I would just note that my client is 6 years old. She loves all these parties. She's a very loving child. I think she's having a difficult time with this. She did indicate to school staff when her father appeared how excited she was, that one of the staff told her, "You're getting picked up today." And to her, that indicates, "Oh, my dad's here to see me." She was very excited, which made me think of what the AFCs at the trial level were saying, which there was a constant excitement that my client would feel, and then disappointment when he wouldn't show up for the visitations during the court proceedings. And I would also note that the trial AFCs all indicated that there was a pattern that would go on where there would be time between court appearances. Father wouldn't be around. The court appearance would be approaching, and then he would be active. He would exercise.
Do you know where the father is? He still living in Brighton with his girlfriend?
So over the summer, I believe that he was not, but I think he is now, based on my client indicating to me on my visit with her last week that he did go, that she stayed at the girlfriend's house. And the visitation that took place last week, Ms. Buntley went on a vacation out of town, obviously, where grandma reached out to dad to say, hey, I'm going out of town. And can you just drop her off with my mother, my client's great grandmother? And then there was a bit of a confrontation that took place over phone. I can be happy to. I spoke with Miss Buntley's supervisor at work, who was a witness to the phone call. I could describe her view of what happened there. However, the father did keep the child, my client, for I think it was a few days. It was not what was in the temporary order.
Okay.
Did she have to go back to court and bring an order? Was there any litigation that had to happen to get the child back?
No, this most recent week.
Yep.
No,
Yep.
there was not.
Okay.
She was going out of town, she returned from town, and the child was returned. Is that what happened?
I believe, and I don't know if other counsel could speak to this, but then he returned her once it was mother's time to exercise visitation.
What are you asking us to do with this Michael B information? What should we, you want it to be remitted for immediate hearing on change of circumstance, best interests, extraordinary circumstance? What should we do with this Michael B information?
Well, my first ask would be to reverse and grant custody to Ms. Buntley, but if your honors do not take that route, that would be my ask to remit and then have the court make a best interest determination.
And your argument on the merits is that the grandmother proved extraordinary circumstances and it should be remitted for a best interest determination.
Correct.
Maybe she wins that, maybe she doesn't, but at least she's in the game.
Correct.
Thank you, counsel.
Thank you.
May it please the court, Brian Jones for appellate grandmother Yvette Butley. Domestic Relations Law 72 addresses the central issue in the case, which is grandparent custody. A grandparent has standing to seek custody if a child has been living with them for 24 months or longer. And although the 24 months is not required, there is the clause that allows courts to consider other like extraordinary circumstances, which is the clause that allows more of the totality of the circumstances to be considered.
That's what we did in Tuttle.
Yes, yes, within Tuttle. Here, the grandmother established extraordinary circumstances. She was pro se at trial, and it's important to note that in a companion custody proceeding that was tried at the same time that involved the same mother, but a different father, so this child's older half-brother, the referee found extraordinary circumstances existed. And in that case, there was a father who was regularly involved and had constant contact with the brother. Yet when it came to this child, the referee did not find extraordinary circumstances existed, where the mother has significant mental health challenges that have begun to be addressed. But the father and mother both have constructively abandoned or actually abandoned the child at different points, whether it be by leaving her with nothing at her older brother's grandparents' house in Mississippi for months at a time while mom takes off to travel, or father who disappears for months, if not years at a time. I mean, there's persistent neglect in the sense that there's no substantial repeated continuous contact by father, and there's no plan for her future. So there's a child who is excited when dad shows up, but has the constant struggle of, will he come? And will she be left waiting at the public safety building yet again?
This child has been living primarily with the grandmother for a number of years. I think we're on 5 years now.
It is 4 years and 5 weeks.
Okay. And has the father ever had an overnight visitation until, it sounds like he might have had one just recently, but before that, during the pendency of this case, was there an overnight, or it sounds like there might have been one or two perhaps?
So when the trial was going on, at that point, if I'm remembering correctly, he had 2 overnights before the proceeding started when the child was an infant. And then when he came into the picture and paternity was established, Eventually he was granted overnights. I believe it was Saturdays, every other Saturday, every third Saturday, but he did have overnight time during this.
Did he exercise it? There was some indication. He had said he maybe had it once or twice at trial.
At trial, he initially did only have it for the 2 times. He did exercise it later on when it was awarded to him. My understanding from the AFCs and the record is that he was consistent in the weeks leading up to trial, or the weeks leading up to court appearances, as similar to what happened for today. And then after the court appearances, he would become less consistent. So there was time, it wasn't consistent time. It was a come and go, not know what to expect sorts of things. Our client would reach out, there would not be a response, or it would just be, she would not hear anything from him. It got to the point where she stopped showing up at the public safety building because it had been so many weeks without hearing from him.
What about a support order? Is there any support that is in effect?
Not that I'm aware of.
So counsel, what are you asking us to find based on the record before us that extraordinary circumstances have been established and that we need to then send it back for purposes of best interest analysis?
Yes, unless the court feels it appropriate to make the call themselves and award custody.
Thank you.
Okay, thank you.
Good afternoon, Your Honors. May it please the court, Blanche Kadeska, pro bono counsel for respondent appellant Dominique Smith. I would first like to address the question of extraordinary circumstances that was just before the court. Although the parallel determination as to the half-brother did find that there were extraordinary circumstances, it is clear that Ms. Smith, the mother, has had an acute and strained relationship with the brother, Nico. In addition, in the court's finding there, the referee determined that Ms. Smith has been working towards her mental health, has shown that she will continue to work on her relationship with Nico. And in any event, the law states that determinations as to children should be considered independently and not together. Your Honors, despite the referee's finding that Ms. Smith is fit to parent, his decision and order deprived her of primary custody in comparison to Mr. Morris, who's a practical stranger. As you have heard from the other appellants here today, neither believe that Mr. Morris is fit to parent, and he continues to show an inconsistent presence in the subject child's life. Ms. Buntley is also unable to prevail over the issue of extraordinary circumstances and cannot take primary custody without showing that. And so the issues before this court are only as between Ms. Smith and Mr. Morris, which parent would serve the best interests of the child. And it is abundantly clear that Ms. Smith is that parent. The 3 issues here are the referee's incorrect finding as to the issue of parental alienation, that the referee's determination lacked a totality of the circumstances analysis, and that Ms. Buntley fails to show extraordinary circumstances. On to the issue of parental alienation, the court's order had a limited reasoning. It focused on disputes, violations, efforts to minimize or frustrate Mr. Morris's participation as a parent. But this is legal error because it was only one factor that was considered as opposed to a totality of the circumstances analysis. Setting that legal error aside, there's no factual evidence of alienation. Yes, there have been some quarreling between these parties, and sometimes there are disputes, but that is the case for any family. And these issues between the parties do not rise to a level of finding parental alienation as to Ms. Smith. Ms. Buntley's counsel today just stated that Ms. Smith tends to go on these occasional trips to Mississippi, which is not evidence of her being unable to parent the subject child. She attends when she does go to Mississippi, there's no evidence on the record that she has left the child alone. And in addition, the children enjoy their time to visit the half-brothers' family members. And now we'll just go through the best interest factors really quickly to showcase the differences here between the mother and the father. As to the first factor, continuity and stability of the existing arrangement, although Naima has lived with Buntley over the course of 4 years and 4 weeks, I believe counsel just said, the only thing that would change in Ms. Smith's care is essentially a roof over her head. She's engaged in her daily life. She knows her teachers, volunteers in the classroom, and continues to foster the relationship between the subject child and her half-brother. Comparatively, Mr. Morris living with him would be a major disruption to the subject child's life. He's only had her overnight a few times. On the record, he stated that he's not familiar with her nightly routine. It's also been testified that there's difficulty for her reintegrating into her school life when she does visit him. And when asked about homework, he testified that it's not the usual thing that we do. The second factor, as to home environment where a parent is seeking custody, we know that Ms. Smith resides in a 2-bedroom apartment, and comparatively, Mr. Morris has an undependable living situation. As our prior counsel have already mentioned, as of right now, he is living with the girlfriend, Carla Alvarado, but there's no certainty as to whether that situation will continue to be stable.
So you understand that for a period of time recently, he was not living with Miss Alvarado? That was alluded to by the AFC? Or are you not in a position to know?
I'm not in a position to discuss his living arrangements. In terms of the financial status between the parents, Ms. Smith receives monthly benefits from Veterans Affairs, as well as Social Security, which is remitted to her children. She also continued to pursue her education and enrolled in Monroe Community College, obtaining a psychology degree, showing her efforts to continue to be able to provide for her children. Mr. Morris is self-employed. We are uncertain as to his financial situation or any of his capital for that matter, which was not discussed on the record. As to the fourth best interest factor, which is the emotional and intellectual development, as I've stated, Mr. Morris continues to be inconsistent in his presence in the subject child's life, whereas Ms. Smith continues to volunteer, pick her up at events, attend major events such as graduations and other appointments. As to the fifth best interest factor, which is the need to live with a sibling, although living with Ms. Smith would not permit the subject child to live with her half-brother who was in the parallel litigation, Ms. Smith does have another child who she had during the trial court. So she would be living with this younger child, but then also Ms. Smith would continue to foster that relationship with the half-brother. And the sixth factor, which is not always considered by trial courts, would be the mental health of a parent. The parties continue to discuss Ms. Smith's mental health, which it was discussed thoroughly throughout the trial court. And the referee did not determine Ms. Smith to be unfit. And in any event, a history of mental illness would not preclude her from an award of custody. So the speculation and the possibility of relapse is merely speculation. It's conjecture. It's an assumption that what has occurred in the past will continue to occur, and there's no evidence on the record that Ms. Smith would be a danger to herself, to her child, or other individuals around her. The only party who was present for the most recent incident, which was her brother, Jaden Smith, testified on the record that she was not a risk or a threat to anyone. And again, as to the court's parallel determination that they made as to Nico, the court stated and commended Ms. Smith for her refreshing ability to discuss these issues and to be candid with the court as to what has been going on.
Counsel, you should begin to wrap up.
Yes, Your Honor. And finally, as to extraordinary circumstances, again, Ms. Buntley does not show that there are extraordinary circumstances. And without being able to show that, there will be no balancing test between the grandmother and the mother. So the only question before the court, as I have mentioned today.
You want us to frame this as between the mother and the father and not as between the mother and the grandmother.
Yes, Your Honor.
Because your argument is that extraordinary circumstances have not been demonstrated, so we don't get to a best interest analysis of the child.
Not as to the grandmother.
As to the grandmother.
Yes, Your Honor.
Yes, I understand. Thank you, counsel.
Thank you.
Good morning. May it please the court, Sabrina Bremer on behalf of Mr. Tyrone Morris. I'd like to initially address the Michael B. statement from the AFC. If this court is going to find that statement dispositive or highly relevant to its decision, I would ask for a remittal because based on conversations with my client has a different understanding of what happened and why there may have been lapses in visitation over the summer. In terms of a disagreement over what the temporary order provided over the summer. And then as referenced by Ms. Buntley's attorney, that she no longer went to the public safety building after some missed visits. And it's my client's position that he has evidence that he has gone to the public safety building, received a stamp that he was there and the child was not there.
Did he move out of Miss Alvarado's home in Brighton?
No, he's still there based on our conversations.
He's been there throughout?
I did not confirm whether there was ever a break in that, but I can say as of our conversations over the summer and then more recently this past week, yes, he's with his partner still. So I agree that the grandmother has failed to show that she is standing to pursue custody as a non-parent. Extraordinary circumstances is a high bar, and the period of time where a parent is seeking custody is entitled to little weight in this determination over the relevance of that period of separation, because Mr. Morris, since March 2021, has been seeking to regain custody of his daughter. And the court, after extensive litigation, determined that his ability to act as a full parent was frustrated at some times by other parties in the litigation. I think that is borne out in the record where in the family court had the benefit of seeing this testimony in person and making that credibility determination when you have parties with very different accounts of what happened. There might be an allegation that he didn't come to a school graduation and Mr. Morris testified, well, I was told the wrong day. There was, during his visitation time, there were other family events scheduled that impeded his ability to have his visitation time with his daughter.
Would you acknowledge he got off? Didn't take a great deal of interest at the outset. I know he then grew and he wanted to more and more contact with the child, but at the outset, he did not want mother to have this baby, finds out she's going to have him. He goes to Puerto Rico, my understanding, with another woman who has impregnated, doesn't appear to have a job lined up there, doesn't have family. He's just going. And when asked why, he's I'm going to live my life. He goes there. Then he gets incarcerated there. According to his own Facebook, he was there for a long enough time that he became fluent in Spanish for domestic abuse. I don't know the truth of all that, but it's his own Facebook. I believe that relationship with the woman he went to Puerto Rico with did not last. And then he comes back to Rochester, and that's when he starts to engage. So he got off to a rough start. Your position would be is that he's improved and he's gained some trust, and if we affirm he gets sole custody, the child has never really lived with him ever, been with the grandmother for a number of years, comfortable there with a half brother. If we affirm it's going from 0 to 60 for the father, he has very limited visitation, all of a sudden sole custody. Yeah. That's what we're looking at here, right?
Yes, he would have primary residential custody and sole decision-making power, but the child would still have time with her half brother and with her mother. And if there's a change in circumstances, then the parties can return to court. But based on this record, I do think that the family court's original order should be affirmed. Looking at, for example, Jose C. versus Janet V., there was also a lengthy period of time where the child was not in the parent's custody. But because there were no extraordinary circumstances, the child was returned to their parents' care. Unless this court has any further questions.
No further questions, Councilman. Thank you. Thank you.